Yes, Mr. Yes.
Lordship, may I mention the matter with the prior permission? Lordship, item number 67. Lordship, the urgency is that there are certain affidavits being filed by the contemners to satisfy our claims. And then again, they have not complied with those affidavits. Lordship, then again, a contempt lies against them. The second urgency is that there are certain submissions which have been made before this court. There is a stay by NCLT. And this coordinate bench of this court has clarified that there's no stay. Lordship, this is an urgency, Lordships. Lordship, we request an audience at Lordship's convenience. Today, whenever Lordship is convenient for hearing of this matter, 5-10 minutes will be sufficient for us to address this court.
In course of the day, in this, if it doesn't reach in the first half, we'll see in the second half.
Please.
Oh, serial number 80, my lord.
18.
This serial number 80, earlier already this office objection was already dispensed.
80.
It is again repeat.
Serial
80.
Yes, what is?
And
to-
I have also given the process as directed by this court. A copy of written submission.
No, we don't know what is it.
Okay.
It is-
Anyway,
My lord, serial number 86.
What is for, what are you mentioning for?
only for my question is only for the issue of notice, process has already been given. That's all.
Process is?
Process is already.
Already paid, process already paid.
Process is already paid already.
Yes.
So we'll ask the office to verify, learned education. So what, if-
Honors notice also they can go.
so we'll take up when it reaches.
Serial number,
Yes,
my lord, serial number 86, my lord. Appear for the petitioner in this.
80,
86, my lord. 86, my lord.
what do you want?
I appear for the petitioner, my lord. We filed a memo to withdraw the PIL. My lord, there was an order which we had to comply, deposit 1 lakh rupees. That also we've complied with that, my lord. I may be permitted to withdraw the writ petition.
I'm for 10 and 11, 12 minors. I'm for a response.
86. Your Akshay,
Yes, my lord.
learned Akshay BM for the petitioner. Six permission to withdraw the present petition.
File, my lord.
By filing memo dated 10/1/2025. The petition was styled as public interest petition, in which it was a public interest petition.
Yes, my lord.
In which the prayer was inter-alia to direct the constitution of the special investigating committee to investigate into the malpractice. Why are you withdrawing?
My lord, the state has initiated criminal action. My lord, FIR is registered.
This
my
is
lord.
committed by, alleged malpractices committed by this number 8 to 11 banks. Alleging that they were in collusion with the state government officials. It was stated on the page of the memo that petitioner desires not to, is not interested in prosecuting the petition inasmuch as the criminal prosecution.
My lord, the state is already, my lord, initiated criminal action, so petition will not survive, my lord.
Have already initiated
Proceed.
criminal action in the subject matter.
So petition becomes infructuous. my lord.
On 6/1/25 paragraph, the court had passed the following order. Not permitting the petitioner to withdraw the petition in view of the fact that the petitioner had not deposited the cost of rupees 1 lakh, which was directed to be deposited as per order dated 1/7/20. Today, when the petition comes up with request for withdrawal, it was stated by learned advocate petitioner that the cost is already paid, cost of the 1 lakh is already paid. The memo dated 1/10/125 is taken on record. The petition stands dismissed as withdrawn. The cost of rupees 1 lakh shall go to the Karnataka State Legal Authority, Legal Services.
Much obliged. ma'am.
My lord, this is an SC/ST matter, my lord.
Matter in serial number 7 in list number 2. List number 2.
What is
May I
this number?
persuade lordships to kindly grant me a week's time.
You can do. You can.
Lordships, you may kindly have this matter 10 days afterwards. Since senior's wife has been taking medical treatment today.
Whose wife?
My senior's wife, my lord, and she has been hospitalized. Therefore, there is personal inconvenience on my part.
Serial number 7,
Serial number 7, Mr. N.G. Sridhar.
learned advocate, Mr. U. S. Sridhar,
I IP for Mr. N.G. Sridhar.
learned advocate. Mr.
N. Ravishankar.
N. Ravishankar stated that since the counsel for the petition appellant has some personal difficulty, for my week's time may be granted, stand over to 23rd January,
27th.
27th January.
Yeah.
28, 20, 27 January.
Why?
Why?
28th, it may be. 28th. It's okay.
4th February.
Great.
Serial number 6, my lordship, list number 2. For appellant in this case, my lordship.
Hmm?
Serial number 6, my lordship, list number 2.
Yes,
Serial number 49 of list number 1. Counsel for the complainant, my lord, is not keeping well, my lord.
49.
49.
It may go to 19th February.
Not serial number 46 in the same list, 46.
Matter pertaining to the PTCL Act, my lord. It is a fresh matter. By virtue of delay and laches, my application before the Assistant Commissioner for Restoration of Land to me has been dismissed, my lord. Now, because of the 2023, pursuant to the 2023 amendment to the PTCL Act in Karnataka, my lord, I have filed an application for reconsideration of restoration, my lord. However, the same has not been done, my lord. And my writ petition was dismissed prior to this amendment, my lord. Hence, I filed a writ appeal and come before your lordships. The matter is of grave urgency, my lord, because
No. 4th February. 4th February.
4th February.
My lord, serial number 46, my lord, I am appearing for complainant. The contempt petition will not survive for
Serial number?
consideration. 46, my lord,
43,
46,
46.
please, my lord. Appearing
46.
for complainant.
CC contempt petition 307/24.
I'm
Learned
filing
advocate
memo.
Mr. Chandranath Ariga.
Yes.
Chandranath Ariga K. For the complainant desk petitioner. Files memo. Dated
List number 2, serial number 6, my lordship.
memo dated 15/125, which is taken on record. The memo, in the memo it is stated that the contempt petition does not survive. The disposal of writ appeal number 154 of 2024. Full stop. Memo is taken on record. The contempt petition is dismissed as not survived.
Obliged.
Petition is
Serial-
filed on 14/10/2000.
Yes, Mr.
Serial number 71, my lord.
You want to
I'm
mention?
compliant.
Yes.
Fair for appellant.
Serial number
Serial number 71, my lord.
70. Yes. So what is the request?
Non-compliance of office objection.
Office submission time will be granted. Yes.
Lord, serial number
Yes, Mr.
But the
Sir.
petition is filed on 14/10/2024. Public interest litigation. Some persons are obstructed the public road and authorities are not taken action against them. This PIL is filed there.
We will instead you remove the office objection.
Pardon?
Once you remove the office objection, then convey to court officer. to
Office
list.
objection is already complied.
Then see that it is listed without acceptance of matter. It will be listed within 1 week.
It is filed on 14/10, madam.
It will be listed within 1 week, we are saying. What more you want? Yes,
Serial number 34.
get the number. Get
We are
it.
for the
Don't
respondent
accept
numbers.
memo, but get the number. Yes.
Serial number 34, my lord. We are for the respondent number 6.
30, 34.
34. Senior is inconvenient, my lord. Kindly grant 1 week time.
18th February.
My lord, serial number 6. my
Sent
lord.
out to 31st, sent out to 18th February as requested by learned advocate for the petition.
My lord, list number 2, serial number 6, my lord.
But the tender matter, there was a order of this honorable single judge on 9/12/2024. Respondent haven't complied, so we have filed a contempt on that. This writ petition will become infectious on 25th Jan, as 90 days of tender period will get over. Hence, there is a grave urgency.
22nd,
25th of
so 22nd. Yes, madam. Yes.
My lord, list number 2, serial number 6, my lord, for appellant in this case, my lord.
Ah.
Place for weeks time, my lord.
Why?
There is some inconvenience, my lord. Senior inconvenience, my lord.
22nd, as requested by learned advocate petition, conversion 6, sent out to 22nd of January. Yes,
My lordship, my case was, contempt case was listed on the 7th of this January. And I prayed for the next date was given, I prayed for 20/20th, but it has inadvertently that gone to 2/8/20th. So I request for the 20.
it doesn't
Because
make,
I'm going to Delhi, that's why, because physically I will be able to bench.
file IA. If the date is given judicially, it will not be changed. You're going somewhere is no ground. Yes,
I will attend through VC only.
you file IA.
I
If
have
you want
filed
to-
the IA. I have filed the IA today only.
IA is filed.
I have filed today only IA.
This is not IA. You don't.
No,
IA
this is receiving. No, this is receiving.
You file then mention. First,
Serial number 21, my lordship. Senior is, have some personal.
serial number
Serial number 21. 21,
21.
21, 21,
So-
21.
What do you want time?
Yes, my lord.
3 days.
20 on Monday, my lordship. 20. Yes, sir.
We'll issue notice 3 days delay, notice returnable on 19th January, 19th February.
My lords, in that it is urgency, my lords.
There is no way out. There is a delay of 3 days.
Senior is having some personal income, so 20,
20,
Monday.
all like 20.
Any mention through VC, sir? Serial number 1, sir, writ appeal to Siddharth Padmaraj Desai.
For the appellant's lordship. For the appellant's lordship. Matter pertains to the overlapping of exams, BCom and CA exams, your lordship. This honorable court had granted interim order. I would like to place one document for the coming semester. The CA exam schedule is out. The university, my instructions are that university will see to it that both the exams, BCom and CA exam will not cost that.
For original petitioner or university?
I appear for registrar through registrar university, your lordship. Petitioners are the respondent, they are the students. They had sought for an exams to be rescheduled, which was commencing.
So what survives now?
But so far as the writ appeal is concerned, my lords, it may not survive.
Their only concern was that
But
on the
our-
last date, they made submission that the coming semesters, the university should see to it that both the exams should not clash. I would just like to place on record the Chartered Accountant Institute's public announcement for the dates. The university has instructed that they will see to it that the BCom exams and CA exams dates do not clash. That is what my instructions are.
We will say that nothing survives after.
Yes, please.
That could be considered, my lords, in the writ petition.
Yes.
The pending writ,
It will not survive.
no, my lords, writ petition is pending. My lords, our endeavor, my lords, is that every time, my lords, what is happening is that the BCom examination, my lords, and the CA examination, which are, my lords, complementary to each other,
That is
are
not the-
held, my lords, on the same day, same time, my lords.
Maybe that is not the business of the court.
Yes.
Correct.
Yes.
Now, my lords, they are making
Palpably
submission.
something wrong or arbitrary, is there, their lookout, how to hold, when to hold, what to hold. Exams.
My lords, our difficulty, my lords, is that the BCom, my lords, students who are willing to take, my lords, the foundation examination and the intermediate examination of CA, my lords, are faced with the difficulty, my lords, that the examination, my lords, is scheduled on the same day and same time, my lords. Though, my lords, The pan-India examination, my lords, is
In any
CA
view, this,
examination.
In any view, the present appeal will not survive.
Appeal, my lords will.
Appeal.
Omnibus you can't go on at a time. Original petitioners. Heard learned and referred to the respective parties. There are original petitioners, respondents hearing, or the students who filed. It's a PI,
No, my lords, it is not a
filed a
PA.
petition. Raising a grievance. There, the BCom examination being conducted by the respondent number 1 university or left with the examination to be held and conducted by the Institute of Chartered Accountants of India. And that the dates the dates of both the examinations had been clashing. Full stop. On a single judge, paragraph. Granted interim order. Postponing and deferring the holding of BCom examination, which was already commenced.
Commenced.
Full stop. Learned single by order dated 10/1/20. Paragraph. Against the aforesaid order, writ appeal was filed by the university. Full stop. This court passed the following order, following interim order. On 12/1/25. So we notice वहाँ से लेकर पूरा process schedule. It was further directed that the appellant university shall take appropriate steps to see that the examinations are conducted as per schedule and that wide publicity in print and electronic media is given to avoid any confusion amongst the students. Full stop. The honored advocate for the appellant, Mr. So-and-so stated that pursuant to the aforesaid order dated 12/1/25, all the examinations are held.
All the examinations are being conducted. We have taken paper publication and wide
All the
publicity is also
examinations
that
for
documents.
BCom degree has been conducted by the university. Are being conducted.
Are being conducted. Worship.
The interim order granted in this appeal has worked out for itself. In the aforesaid view, nothing would serve as the exams are conducted. So nothing would survive in this appeal.
Yes.
The writ appeal is disposed of in terms of the interim order.
Please.
Paragraph. . The principal paragraph in the main writ petition was to direct the Discon University to reschedule the BCom examinations for the subject concerned, which were still to be conducted. Notified under notification dated 3rd, 12/24. The alternative prayer made was to direct the university to make the provision to enable the petitioners to take their BCom examinations. It was yet another prayer to direct respond number 2. Who is number 2?
Registrar
That is the
evaluation.
appellant here in Lordship.
Register
Registrar evaluation.
to decide the representation dated 18/12/25 of the petitioners, in which the very grievance was raised. Full stop. Noticing the pleadings and the prayers of the petition, they pertain to the conduct of the examinations for the academic year 23-24.
24 and 25 Lordship.
24-20. Full stop. Even the representation in the annexure G. Even in the representation in the annexure G, page 83, the rescheduling of the examination is requested. Rescheduling of the current examination.
70.
Rescheduling of the current year examination is requested. Full stop. In the aforesaid, nothing survives in the writ petition also. The writ petitions are accordingly disposed of as not surviving. Full stop. Any subsequent development for future year may give fresh cause of action for the petition. However, in respect of which this court does not express any opinion on merits. Accordingly, both the appeals and the writ petition are disposed of. The registry is directed to notify the writ petition today on board before this court in view of the disposal as provided for in this order. The formal listing of the appellant. Yes, next.
May I make one request, Lords, with my Lords, kindly, Lords. This is a case where, Lords, every time, Lords, it is happening. Let the, Lords, university consider, Lords, that aspect.
University will
Lords, the
consider.
BCom and CA,
We have
Lords,
I've instructed university. That is what I am told. We will consider next
that may
semester. it
kindly
will-
be recorded, Lords, because
Don't need to
every
record
time,
your
Lords,
notes.
it
It
is
will be
happening. The
considered.
students are, Lords, compelled to come before this honorable court. Lords,
No
if
previous.
it is any other examination, Lords, certainly, Lords, I would
There are
not have.
many circumstances, many exigencies. We can't generally.
Lords,
They
two
will
and a-
accept,
We'll keep
a
in mind.
priori in all normal circumstances.
2.5 months, Lords, prior to that, Lords, they have notified. In the month of December, Lords, they notify. They notify.
Their grievance is legitimate. So
I'm told them that.
for limitations, but you see.
I will consider it that way.
If that could be, Lords, if they consider, Lords, even, Lords, the representation is not considered till date. Lord, we
It will-
have earliest, Lords, approached them,
No.
stating that, Lords, the exams are overlapping. They don't consider. That is
no
why,
such
Lords.
overlapping
Otherwise,
for
Lords, I
past, but-
wouldn't have, Lords.
No, Lordship may kindly see.
Press cause of action, only line, delete it. Delete the line about the press cause of action. Not to write, to be deleted. Alright. Not to be written, to be deleted. The line which is regarding press cause of action. At this stage, learned advocate Mr. So the original petition submitted that the university may consider the grievance of the students, namely that the university examination and other examination often clash to deprive the petitioner from competing in the professional examination. Full stop. Learned advocate to the petitioner. submits.
Direction may not be issued.
Will-
We'll consider it, Lordship.
The
because,
university will consider and look into the matter.
We'll consider it because direction issued, then every
We'll
time
consider-
new.
Observation,
petition will
Lords,
be
would certainly,
We'll
otherwise they won't
we-
be considered.
1 second, we'll consider the grievance in proper light.
filed. Grateful.
Grateful.
Content matters. Still number 2, Mr. Chikkanagowda.
Your Lordship, appearing for the complainant, Your Lordship. Humble submission, Your Lordship.
Hmm. This order was passed in 2017.
Please, your lordship, a humble submission, the counsel for the accused have filed two compliance affidavit for which I am seeking a certain time period for filing the objections to it.
What is the compliance?
My lords, the status reports have been filed, my lords. Affidavit it may be, but it is in the form of status reports. The complainant, my lords, has filed an application under ex-serviceman quota, but he himself is not an ex-serviceman, but a police constable, my lords. The formal endorsement has not yet been issued, my lords, so it will be issued and we will file our affidavit, my lords.
Denying the,
Please, my lords.
do it, this is old matter, even other will not.
Please, my lords, we'll do it within a week's time.
Your lordship, another submission.
Madam,
your-
this is not maintained after 1 year, section 20 of the act. Still, since they have filed some compliance, we are keeping it pending.
Your lordship, but with regard to the second compliance affidavit, what the learned counsel has filed, we haven't received any copy of such.
Obliged, we'll file it again, my lords, anyway, we'll.
File it by 22nd of, to be listed on 22nd of January at 2:30.
Obliged.
Seal number 3. Bina.
Your lordship, page number 32. The direction is to form under the Karnataka Apartment Ownership Act. And if your lordships go through page number 34, the direction given by the respondent state is to form under the Cooperative Societies Act. It is not only violation of the order, your lordship, the intention is to scandalize the order of the court itself. There are multiples of cases, your lordship.
Who are you?
Lords, the direction is for the Welfare Association to register under the Act, my lords. Page 32.
I am a society, your lordship.
But you have to register yourself.
No, that is done. But the point, your lordship, here, I am a welfare society. We have approached the court. Along with that, some other people has also approached. All these cases were connected together. And your lordship has given a direction to form under 1972. In all these cases, this respondent accused were also a party. They were aware of this, what exactly the direction. But the Cooperative Societies Registrar's Office, after this order is passed, giving a direction to form under 1972, they issued a letter. They issued a letter mandating us to form under Cooperative Societies Act. So they
Lords,
just want
this
to
is
do- they just
beyond the,
want to-
my respectful submission is, this is beyond contempt jurisdiction. Here, there is no direction to the state. My lords, that was another case where there was a direction. Here,
No, your
there is a direction only to the Welfare Association to register. So they are saying about a letter, that is a different cause of action, my lords.
They were also a party in that, your lordship, and they sent a letter to me. You have to form under Cooperative Societies Act. My account itself is also frozen. So the intention of this department, especially this cooperative society, it has to be looked into, your lordship. In fact, your lordship, they are not. on-
Counsel,
Yes.
see, the law contemplates an option is given either for the societies to register under Societies Registration Act or Apartment Ownership Act.
Correct.
In Apartment Ownership Act, if you register, the common area rights are surrendered in favor of the apartment, society. In Societies Registration Act, no such surrender takes place.
Yes.
So the societies will be in a better position to administer if you register under the Apartment Ownership Act. That is the purpose.
Yes, yes,
That is the sole purpose.
yes.
But nowhere in the judgment or in the preceding judgment of the division bench, what is referred to over here, a direction is given that necessarily all the apartment societies have to register under Societies Registration Act.
Your Lordship, then page number 32. In the event the welfare associations fail to register under the Act of 1972, any amount that they would collect would be unauthorized, and the liberty is given to form under 1972.
Exactly, but there is no compulsion on the part of the state that the societies have to be must and should register under Apartment Ownership Act.
Then, Your Lordship, page number 34, what is their direction? The last sentence. It is hereby informed to take immediate steps to register the society afresh under the Karnataka Cooperative Societies Act.
But this does not give rise to a contempt. This page number 34 order notice.
Your Lordship, there are division bench decisions. They are not only defeating this law, this particular order. The division bench order is there, writ appeal 974/2021. And writ appeal 564, last year, Your Lordship has passed an order giving a clear direction. In a residential apartment, you have to form under the Karnataka Apartment Ownership Act. And in a commercial property, you can form under the Cooperative Societies Act. Because, Your Lordship, the scheme of development in Karnataka is little different than in Maharashtra or some other states. Because undivided share is already been sold to individuals. That is the reason we have a specific statute also.
You can challenge this page 34.
No, Your Lordship, I'm not.
And this order may be a good ground for you to.
Your Lordship, I'm not going, with all these things. My point here in this sense, they were also the respondents in that particular
There is no
direction.
direction to the state, my lords, is my respect.
No, the state is aware that the direction is to form under 1972. Then how can they give direction to form under Cooperative Societies Act?
Sir, we are bringing under contempt, maybe a good ground to counter 17-120, but not in the under contempt.
No, Your Lordship, this is
Not to enforce under contempt.
This is the simple thing of which I wanted to bring to Your Lordship's mind. There is a direction from the court. You just direction or liberty or whatever it is, you form under 1972. And on the top of that, this officials, who has given the authority to this officials to form a cooperative society and to issue a direction, then what happens to the court's order, Your Lordship? Court's order is to form, the liberty is given to 1972. How the officials can issue a direction to form under cooperative society? And if Your Lordship reads through the many cases which we have also filed before Your Lordship, the intention is very clear. It is a clear attempt of scandalizing the order. Not only this, there are many other orders too. When Your Lordship says form under 1972, how can they issue an order saying Cooperative Societies Act? That is the only question here.
Heard learned advocate, sorry, Miss Bina PK for the complainant, and learned additional government advocate, Srimati Pramodini Kishan for the respondent upon service of copy of the contempt petition in advance. Full stop. Learned single judge by order dated 21/22. Dispose of the group of the petitions to direct the petitioner Welfare Association to register itself under the Karnataka Apartments of Ownership Act 1972. To further provide that failing which any amount which may have been collected by it would be unauthorized. Full stop. Post the order, it appears that a notice dated 17/1/23 came to be issued by the District Register of Societies, First Zone, Bangalore Urban District, whereby the petitioners and other associations are required to take steps to register themselves afresh under the Karnataka Cooperative Societies Act 1959. Full stop. The contempt is sought to be alleged in respect of the direction in order dated 21st November 22. Whereby the petitioner is to get registered itself under the 1972 Act. Full stop.
And the registration is already been done, Your Lordship.
The contempt petition is misconceived in as much as there is no direction to the state authority which can be enforced under the contempt jurisdiction. Full stop. If the petitioners are aggrieved by what is contemplated and directed in order dated 17/1/23 into bracket page 34, annex B, bracket over, comma, the petitioner may avail independent remedy in accordance with law, in respect of which this court, however, does not express any opinion. The present contempt petition is accordingly disposed of as not entertained.
Seal number 4. N. Narkeshwar. Seal number 4.
I had a petitioner, my lord.
Notice returnable on 11th March.
We have served the notice on the BBP council.
It is
We have
not-
all
Undertake to file wakalat, my lordship.
Yes,
Undertake to file wakalat, my lordship.
pardon,
File wakalat, undertake to.
file it,
wakalat, my
file it,
lordship.
file it. On next,
Seal number 5.
the date may be fixed, my lord.
it is already fixed, Mr. 11th March.
Seal number 5, Mr. Shrikant MP.
It's page number 123, my lord, the order of the learned single judge. Page number 126, my lords, the order portion.
Notice returnable on 20th February.
Seal number 6.
My lords, direction was issued, my lords, permitting filling up of the post by open competition.
Nine.
We made representation to the pre-university department.
Next.
Page number,
In this, fill number 6, there is no time limit prescribed.
my lord, there is in fact, my lords, to fill up the vacancy, in fact, if lordships kindly see, we are permitted to fill up the my lords post from open competition. We wrote a letter asking them, my lords, to start with the formalities because they have to permit, my lords, we have to notify the vacancy in leading newspapers. They are not, my lords, acting on it. Unless they do it, my lords, we cannot go forward. We cannot fill up the post. That's the difficulty. And, my lord, the order was passed, my lords, in January 2024. Almost 1 year, my lords, from the, my lord, the order was passed.
The directions which are brought under contempt jurisdiction contained in order, judgment and order dated 4th January 24 of law, single judge, reads as under. Then quote 1, 2, 3, which are 2, 3, 4. And on page 102, this yellow flag. Full stop. A bare reading of, after quoting, a bare reading of the aforesaid directions. While learned single judge has directed the respondent number 2 to proceed to fill up the reserve the single post of lecturer in English. To proceed with the recruitment process by inviting applications, reopen competitions in respect of the post in question. However,
Or one submission, my
this
lords.
exercise, no time limit is provided for. Full stop. Paragraph. In that view, it is not possible to conclude at this stage that the respondent has committed any contempt of court, much less a willful contempt. Paragraph. At the same time, since the directions, at the same time, the directions of the court should not be permitted to go uncomplied with. Therefore, by providing that the respondent number 2 shall take necessary steps as contemplated in the aforesaid direction of learned single judge, comma, within 2 weeks, comma, this contempt petition is disposed of.
one submission, my lords, probably, my lords, on academic interest. Even if, my lords, no time limit is, my lords, provided in the order. Fact remains that, my lords, as per section 20 of, my lord, the Contempt of Courts Act, it is, my lords, it starts from the date on, my lords, entitled to, my lords, come before this court when my lords, contempt is committed. Here is a case, my lords, I make a representation to act in terms of the, my lords, the order of this honorable court, which is not acted upon. As such, my submission.
In that representation, you you mentioned the time limit?
My lords, in time, I have only said to, my lords, to implement the order.
Now we are providing for time limit and it will be.
My lords, I only with academic interest, my lords, please answer.
So number 7, Akash VT.
Lord, non-compliance of direction.
Notice returnable on
Lords, in
19th
this
February.
matter, we have
Yes.
already passed orders,
Already passed you.
but it's in vernacular language.
Appeal is decided.
Please, my lords.
The directions in the order of learned single judge dated 21/9/24, which is made subject matter of the contempt of court, required the respondent to assistant commissioner to decide the appeal. Taking of appeal. Full stop. Today, when the contempt petition came up for consideration, paragraph learned additional government university promote education produced copy of decision dated.
Lord, this is some other case order, Lord, not this case.
Fine. I'll stand corrected, my lords.
Then verify, madam. So shall we?
I'll take notice, my lords.
Notice it on 19th of February. Learned additional advocate, government advocate, promote education, accepts notice on behalf of number 1.
Please.
All,
Oh, number 1.
number 1.
So number 8,
That's number 2.
KV Narasimhan.
Number 2.
My
Number
lord,
2. 8
in-
notice returnable on 20th February.
my lord, in this case, my lord, they have already issued an endorsement, my lord, rejecting my claim. Liberty may be reserved
Learned
to
advocate
challenge.
for the petition, Mr. So-and-so fairly stated that
Satya.
pursuant to the direction of learned single judge to consider and decide the representations of the petitioner from an endorsement dated
11/12/2024. 11/12/2024.
11/5,
12, 12.
11/12/2024 is already received. Copy, produce copy.
I'll produce the
Copy
copy.
whereof is produced in the report. Post of any of the endorsement, the directions of learned single judge stands complied with. The contempt does not accordingly disposed of. Paragraph. Learned advocate for the petitioner submits that liberty may be reserved for the petitioner to challenge the aforesaid endorsement dated 11/12/24. Merits. Full stop. Such liberty is reserved. However, this court has not expressed anything on merits in that regard.
Okay.
So number 9, the Shilpa Rani.
No, for accused.
9.
Even-
Notice returnable on 21st February.
Copy could be there as well. Number 10,
Hearing on behalf of the
Shankar
company.
C.
The order of this honorable court, which was passed on 19/12/2024, my lords, stands not complied by respondent number 1 and 2, my lords. Therefore, this contempt has been filed. Lords, the petitioners are renewable energy companies, my lords, intending to set up projects in Bellary and Tumkur. There was a specific direction given to the respondent number 1 and 2 to issue a character certificate in the form of a GNA authorization, which is a precondition to setting up or doing any infrastructural activities.
What is the main petition for?
Well, it is just a mere direction, my lords, to the only limited prayer, a direction to the respondent number 1 and 2 seeking for an authorization, my lords, as per the GNA regulations of the central government, my lords. My lords, after hearing the petition, my lords, this honorable court was pleased to pass an order, my lords, directing the respondent number 1 and 2 to consider our application and pass appropriate orders. and issue a authorization, but they've not done so, my lords, so far.
No, what is the prayer in the main petition?
My lords, the prayer in the main
Same prayer.
petition
Same prayer.
is for considering our representation issued to respondent number 1 and 2 and granting an authorization, my lords, to set up renewable power park in the state. My lords, if I may, my lords, it's at page 58, my lords, of this petition.
So then after this interim order, what remains in the main petition?
Nothing else remains for survival.
That's an oral order, my lords, dated 19th December 2024. It appears that the final order is not yet passed.
Please, ma'am.
Not entertained. It is not in dispute that the order dated 19 December 2024, passed by learned single judge in writ petition number 35002 of 24 is an interim order. The proceedings of the main petition are still pending at large on merits to be considered by learned single judge. In the aforesaid view, when the order is interim, no final rights of any of the parties are not finally crystallized. The court is not inclined to exercise the contempt jurisdiction, or particularly it could not be said that the
Well,
order.
in fact, 7 days was given for compliance of
There's
this
a
order.
trapping of finality. Full stop. The issue and the grievance, which is subject matter of contempt, will be decided in the main petition, where the petitioner may work out his rights and remedies without expressing any opinion or merits, the contempt petition is not entertained and disposed of.
Please, ma'am.
Matters, still number 11. Mr. Gurudev I. Gachinma.
It's appearing for the petition.
Point number 7, This grant, you want some grant allocation.
Yes, my lords, this is with regard to Amruta Nagaruttana Yojana, my lords.
Which is the decision? Same, identical. Allocation of grant cannot be grant to one ward and the other ward and one state, other state. Come at 215, we'll get the judgment. 230.
Still number 12. To Dhananjay CP, still number 12.
They are thinking for clearing of encroachments.
In a lake.
I apologize, I just got this morning, I have succeeded in clearing the encroachments. I have to file it with a memo. I have produced the photographs also.
What was the encroachment?
My lord, some farmers had, my lord, encroached upon it, though they were growing some crops. We have got that removed, my lord, though it was for a small extent, and the bunds that have been constructed are there in the photograph.
But you should fence it entirely, keeping it.
I will direct them to fence it.
So let the petitioner come, 230.
My lord, could I file it with a memo, my lord?
We do. So,
Still number 13.
My lords, this matter, in the lake area, my lords, 1 acre is being reserved, my lords, for the purpose of burial ground, my lords, where there are bore wells, and this lake, entire lake, my lords, is utilized for drinking purposes for around 2,000 households of 3 villages, my lords. Agriculture, and if your lordships could kindly see the photograph. Annexure C1, my lords, page 57. The area now proposed, my lords, is part of survey number 63, which is a lake in Yandahalli, my lords, which is being, my lords, the Tank and Lake Conservation Act, my lords, clearly prohibits anything else. And this is a low-lying area, my lords. 2 inlets from Devarajaras Canal, which is a big canal, my lords, that will be stopped because of the burial grounds. And it will contaminate the water, my lords, and it will close the lake.
It is proposed burial.
My lords, actually in 2006, my lords, that is what we have challenged here. 2006 Annexure B, page 45. The translation is at page 47, my lords. There is there is an official memorandum by the Deputy Commissioner, my lords. But nothing was being done till 2022. 2022, my lords, Annexure C, page 54, they've started demarcating. Now, my lords, they're demarcating. Even now, it's not being used. That's why we're before this honorable court, my lords. It's not yet being used. They're proposing to use it. Let's say it will destroy the tank lake.
Notice it.
Great. My lords, in the meantime, let them not start burying bodies, my lords. It's a lake area.
We are not burying bodies, my lord.
They permit burying bodies, my lord. And my lords,
This is where, which place?
This is Yandahalli, my lords, Mysore district.
Mysore. There is no other burial ground.
There are, my lords. There are. There are. My lords, this area is being.
My lord, I'll get.
The government doesn't bury, my lords. It will permit to bury. I stand corrected.
Even in this public interest petition is inter-alia that a land portion of land area adjacent to the lake.
No, my lords, it is lake area only. It is not adjacent.
It is according land portion of the land which is part of the lake.
Part of the lake.
Is proposed to be used as burial ground for particular community.
Yes. General community.
Which community?
General. There is.
Not community.
Not
for burial ground. Notice returnable on, we'll say early, detail, 12th of February.
Yes, ma'am.
A response will be filed to the grievance raised in the petition by the authorities before the next month. See that this is not done. The lake appears to be live.
Yes, my lords, it's a lake. I have produced photographs, my lords. It's a live lake.
Area, if you're not.
It's a very,
will start floating.
Yes.
It has become a center of Mysore, my lords, now.
Still number 14. Muhammad Imran Riza, 14%.
Your Lordship, I filed this public interest litigation against my employer for violation of fundamental right or right to privacy which guaranteed under Article 21. The respondent mandated the installation of a security software on the employee's personal device, and but secretly tracking the employee's browsing data and uploading this to their centralized cloud server. The respondent introduced this software like as a security tool which will protect the company's data and will secure their system. But respondent failed to provide any clear information about how the software will use and how it gonna affect the individual privacy.
Yes, miss. What is the problem?
Sorry, my lord.
Yes, what is the problem?
I didn't.
What is the, what is the problem? What is the grievance?
No, that's what, like, as I said, like, respondent mandated the installation of software on the employee's personal device, mandating them, this is the software tool which is necessary for the employment, especially employees who working remotely. And in the email, initial email, the respondent which they sent in that, in page 33, annexure A. So that was the initial email where they have given the steps to install, but failed to provide any necessary information about the privacy policy, about the condition of the software, and what kind of data and how it's gonna work on the laptop. Upon investigation, I found that it was not a security tool. It was the executable file which modify critical system settings on the Windows operating systems and give administrative control to the respondent. And respondents remotely enforce any policies from their centralized cloud server. So as of now, the policies which is applied, which is mentioned in Annex G, page number 42. So these are the Chrome policies.
Heard petitioner part in person, Mr. MD Imran. There is that. That 6 to know the jurisdiction paragraph of this court. The petition seeks to invoke the public interest jurisdiction of this court under Article 226 of the Constitution. Raising a grievance inter alia that because of the certain acts and omissions on part of the respondent, no broker, NOBR of area, BKP, no broker technologies solutions private limited, which is a company, which is a private company. The employees are forced to surrender their digital privacy under the threat of losing access to work tools. It is alleged that the unauthorized control and data collection operates in violation of the provisions under the Information Technology Act 2000. It's contended that the employees of the respondent company is contended that the employees of the respondent company are required to work from home and are further directed to install a mandatory software on their personal devices. It is alleged that certain unauthorized modifications are done in such devices, which has resulted into private violation. As the modifications enable the company to monitor and control the personal browsing activities of the employees without obtaining explicit consent of disclosing the extent of data access. Paragraph. With such premise of case and the pleading, the prayers advanced are inter alia to issue a permanent injunction from installing or enforcing any software or files access against the respondent company. It is further paid to require the company to carry out the independent audit regarding data handling procedures, etc. It is also paid to establish an external oversight committee. The further prayer is to require the company to identify and permanently delete the data which was unlawfully accessed and collected. It is prayed that the company has committed a criminal breach of trust for which it is required to be prosecuted. Paragraph. It is for 3 reasons that the court is not inclined to entertain this petition. Firstly, the respondent is a private company. In all normal circumstances, as also in this case, writ petition, the jurisdiction of the court under Article 226 of the Constitution would not be invocable, and the writ petition, including in the nature of public interest petition, will not be maintained. Secondly, the petition is based on bald allegations without any specific or concrete instance which may persuade the court to look into the privacy violations. Thirdly, the petitioner has made a general prayers which are too ominous to be considered. So for all the opposite reasons, the court is not inclined to exercise this. Court not inclined to enter in the petition. Post of the concrete or individual violation of privacy rights may be a cause of action for initiate appropriate legal proceedings. The petition is dismissed accordingly.
Still number 15, green bench matters. It's a recall.
Yes.
My lord's petitioner is the proprietor of a crusher unit by name Bhavishya Industry. And the license for the same, my lords, was granted on 21st/9/2017, which got expired on 31st/3/2022. After that, my lord's petitioner has complied with the statutory requirements and he is further entitled for the deemed extension.
This is the section 8 amendment.
No, my lord, this is a stone crusher unit.
Stone.
As per rule, section 4(1), my lord, they have to file an application for renewal
My lords,
within 90 days.
as per my instruction, my lords, the petitioner has already complied with the statutory requirements, my lords.
My lord, section 4(1) may be seen.
Like.
Karnataka Regulation of Stone Crushers Act.
Page 638.
So did you made an application 3 months before the expire?
My lords, as per my instruction, the application has already been filed. And my lords,
Before 3 months from the date of before the date of expiry of the existing license.
my lords, for that I have to seek instruction.
Take instruction.
My lord, they say it is automatic. That is
yes,
what contention is. My lord, but that is incorrect for the reason that the section provides for, my lord, a renewal. And it says that in case the period has expired and if it is filed 1 month thereafter, my lord, there are certain conditions to it.
Expired on 31/3/23.
Yes.
22.
And they were supposed to file it 3 months prior to, my lord, 31/3/2022.
So when did they file? After?
No, they haven't filed at all, but they are, no,
But
they are
I-
seeking for commanding of a renewal.
My lords, that must be a typed error, my lords. We are only seeking for direction to the respondents, my lords, for the deem extension of the license, my lords.
You have to comply with section 4(1) or not?
My lords, as per the amended Act of 2020, my lords, we have the benefit of the under subclause 3, section 5, subclause 3, my lords. 2 and 3, my lords. The deem extension, the deem extension to be, my lords, for the deem extension, which is automatic by operation of law, my lords.
Section?
Section 5, subclause 2, my lords.
No, I don't know which
640 of
provision.
Karnataka. Subject to payment of such annual regulation fees as may be prescribed, all existing crusher license granted before the commencement of Karnataka Stone Crusher Regulation Amendment Act 2020 shall be deemed to have been granted for a period of 20 years from the date of original grant and shall be extended accordingly.
My lord, 3(1). Even assuming renewal application is a must.
It is 3(1) is provided by
So they are saying that probably that this does not dispense with section 4(1).
Yes, they have to file an application for.
my lords, for that, according to the petitioner, he has filed, my lords, I'll seek instruction for the same. In the meanwhile, my lords, the notice may be.
Once you seek instruction, we'll issue more than notice.
My lords may grant.
You find out whether any application is made.
Please, my lords.
Because that is the fundamental requirement.
Please, my lords.
On your part. When shall we take it?
My lords may have it
22nd?
tomorrow or day after.
22nd?
Yes. Please, my lords, 22nd.
To be listed at 22nd, on 22nd of January at 2:30.
Seal number 16, so Mahendra, sir.
I appear for the petition. But in this petition, the petitioner seeking for quashment of annexure A, the proceedings of the District Task Force Committee. The petitioner has filed an application for quarry lease, seeking 5 acres of land for excavation of building stone. His application was processed. All the necessary no objections certificates have been received. And it was at the final stage of grant, Lord. At that point of time, annexure A came to be passed. Annexure A, Lord, page number 17. Translation is at 25, page 25. My submission is, my lord, this district task force committee has no role to play in the process of, my lord, considering application or granting quarry lease. It is only the competent authority, it is the senior geologist, who has to consider the application of the petitioner. Rightly, he has processed the application, obtained all the no objection certificate from the revenue as well as forest department. This district task force committee was introduced in the year 2013 only for the purpose of obtaining no objection certificate. The last may kindly see under sub-rule 6 of rule 8. This district task force committee was introduced in the year 2020. Sub-rule 6 of rule 8 has been omitted. Therefore, it is not in existence at all.
This task force committee,
Task force committee,
not in existence.
not in existence. Kailash may kindly see sub-rule 6 of rule 8 was omitted in the year 2020. Now it is the, even otherwise, Lord, they do not have any power to give directions.
You yourself are playing against the, for direction against the district transport committee.
No,
Your prayer is for direction to the very committee which you say they are not in existence.
no, my prayer is against the, Lord,
Number
the competent authority.
Number 4, prayer number C. District transport committee.
No,
You yourself recognize the existence.
refrain from, my prayer is issue direction to district task force committee
Oh.
to refrain from interfering with the consideration of processing of petitioner's application by the competent authority.
So by virtue of which provision the committee is not in existence.
Lord, 2020 amendment, please. Sub-rule 6 of
2023 amendment, 20.
20, please.
20.
Amendment to rule 8. In rule 8, the said rules for sub-rule 6 shall be omitted. Prior to that, Lord, in the year 2016, sub-rule 6 was there. The very same book.
I don't have that insertion, my lord, that it has been substituted. That meant.
We are not getting.
Lord, now,
Not getting which provision you are showing.
Lord, sub-rule 6 was there in the rule book in the year, it was introduced in the year 2013.
Karnataka minor concession rules.
Yes. Sub-rule 6 of rule, please.
Sub-rule 6 of rule 8.
Rule 8. Earlier it was there. By the virtue of that, this particular district task force committee has been introduced.
Doesn't say like what you are supplying.
May I draw your lordship's kind attention, Lord, to rules of 2016? rules of 2016.
66, sir.
16. Even not 66. 86. 86 in the bottom. During 2016, Lord, after amendment, a deemed concept of deemed no objection certificate has been introduced in the year 2016. To oversee that, the district task force committee has been empowered.
Rule number?
Sub-rule 6 of Rule 8. Now in the present rule, that is not there.
We are relying on 16 rules, 16 amendment rules.
No, in order to show that sub-rule 6 of Rule 8 was there in 2016, and subsequently in the year 2020, it has been omitted. Last may kindly peruse that lot. In 2016,
But it is again reintroduced in 2023 in a different manner. 23 amendment rules you check.
23 amendment.
Previous page of 519. complaint, referring it to district task force committee. That is what has been.
No, in 23, it's not there.
It is introduced in 2023. That book, you come to page number 519,
519,
519, you come to 519.
please.
Clause 6, you see it. When no objection is not granted, the matter is referred to district task force committee. And the same thing has happened over here.
No. Here is a case wherein no objection certificates are received.
Okay.
Received, and the application was processed. Even otherwise not, this district task force committee has no power to give directions.
No, it wants to verify before proceeding.
My lord, that's exactly what they have said, my lord. The clearances are given in 2006. We are in 2020,
May-
14 years.
May I make a submission? Your last may kindly peruse. Annexure L.
The committee wants a fresh inquiry.
Yes.
No,
My lord,
Committee.
In that way, it's a premature petition.
my lord may take
No.
the decision of the Honorable Supreme Court in the state of Tamil Nadu versus Hindstone. My lord, 1981, 2 SEC, page 205, paragraph 13. That's enough, my lord.
81-2.
Yes. 1981, volume 2, Supreme Court, page 205, paragraph 13. They want everything to be done in their way, my lord. All these petitioners who come filing these mining petitions.
The state cannot make such.
I can.
submission. It is.
Please see the Supreme
It's
Court
absurd.
decision.
May I make a submission? Last may kindly see. Even in the introduction, the rule which has been introduced in the year 2023. May I read, my lord? The rule which has been introduced in the year 2023.
Page 519.
519. If the deputy commissioner or assistant commissioner of the revenue department or deputy conservator of forest or the assistant conservator of forest or the deputy director or senior geologist, as the case may be, fails to give no objection certificate or joint inspection report under Rule 5 within 90 days from the date of communication, the same shall be placed before the district task force committee in its monthly meeting by the concerned deputy director or senior geologist, provided that the officer fails to issue no objection certificate or joint inspection report as specified in sub-rule 5, shall be summoned by the district task force committee and obtain opinion from the concerned officer in the meeting and record the proceeding of the meeting, and same shall be disposed of accordingly. Lord, whereas in the present case, all the no objection certificates have been obtained. And it is not the case of even competent authority that they have not received the no objection certificate. For instance, Lord, the joint inspection was conducted in the year 2024. The last may kindly see Annexure L, page number 67. This is the technical report submitted on 21st May 2021. The last may kindly see. Go to page number 68.
This precise exercise they are doing.
No, my lord, it is, Lord, in order to hinder the process of consideration of application, and under 2023 rules, my lord, they have to consider the application in a time-bound manner. Now it has been processed. As per annexure L, page number 68, a technical report was obtained. Page 68, annexure L.
So what is that?
Technical report, my lord, for feasibility of granting query list. Thereafter, my lord, page number 70. Deputy Director writes for DGPS survey and drone survey. It is after obtaining all the required no objection certificates. Page number 70. This is dated 30/10/2023. Thereafter, a joint inspection was conducted on 16/1/24 as per annexure N. This is in the month of January 24 with all GPS coordinates. The last may kindly peruse 73 annexure N. Then thereafter, my lord, one more inspection was conducted by geologist as per annexure P, page number 76. That is recently 30th July 2024.
They only
Lord, as per annex,
get the latest report from the Revenue and Forest Department.
My lord, the application is of
latest
the
report
year
has been obtained.
2014. My lord, the application is 21/10/2014.
Lord,
One second. See, first district task force committee was there. Then by amendments, it went out. Then by subsequent amendment 2023, it comes back. Correct? Correct, no?
Yes, my lord.
Yes. Then he makes an application in the year 2014.
Yes.
His application is being processed even till today.
No. His application had been rejected on 28th.
Yes, his application gets rejected,
Thereafter he
but
approaches the
thereafter
court.
he approaches the appropriate authority,
yes.
which set aside that particular rejection. Okay, that means in other words, his application is in process till today. Because of change in law in between, opinions have already been received from the concerned authorities. That is the forest department.
My lord, was for the year 2014. That is the reason why my lord may take annexure A.
See how
10
it can
years.
how it can change today.
My lord, 10 years development, subsequent development, so many changes. Even in a few hours, there are so many changes. If the situation were to be the same as what it was in 2014,
Show me the provision of law.
we have no objection.
Show the provision of law which entitles you to seek for fresh opinions again and again and again. See, because you need to understand, here is a case where he makes an application for grant of license, which has not been granted till today.
My lord,
And that application is alive. In between, he gets, see, whether his contention that district task force committee should not be in existence is a separate issue altogether. That we can come to it later. We are not inclined regarding that. But with regard to getting NOCs from different departments, having obtained once, without processing his application to the logical end, how can you ask for those calling for those NOCs once again?
my lord,
So
that,
in law you
my
can
lord,
do it.
that had been considered, rejected. Then, my lord, this honorable court directed us to reconsider, considering that 10 years have passed by and there is a lot of development. My lord, we wanted to re-verify, to be reassured that we were not making a mistake. My lord, very
Lord,
well.
may I make one submission? Their contention is that they wanted to verify the site whether it is intact or not, for which I made a submission, my lord. From L to P. Recently, joint survey was conducted. Joint inspection was conducted in the year 2024.
It's all right, my lord.
Your last may kindly peruse annexure N. Joint survey is there.
Point out to them. Point out to them.
My lord, he
But
has
because
no vested right.
these
and
are
no
the process.
Right. I don't know why they are demanding as a matter of right the state.
It is a
my
matter
lord. I
of
still
right
don't
only.
understand that. And they want their application to be considered in a particular way, overlooking the provisions of law.
Short term, Lord, because
No, my lord, I need some time.
my predicament is this, Lord. Under 223 amendment, this processing shall be done in a time-bound manner. Otherwise, Lord, I'll lose my right.
Here says of the matter. Notice returnable on 21st February.
Oblige, my lord.
Reply shall be
Lord, a
filed.
short date may be granted, Lord, because
Even that
because
short date.
even for that, Lord, the latest being July 24 inspection, nothing more to be required, Lord.
We are already on 15th, so only 4 weeks are granted.
But again, they may seek time on that day. That is why, Lord, that is the practice nowadays.
Right to defend the state. I don't know all these kind of.
Because it is our experience, Lord, repeatedly for filing objection.
Yes, yes, and he knows the
Objection.
difficulty, my lord, being the principal GA.
But one thing is certain.
My lord, he knows the difficulty.
Your vehemence is more in degree against Mr. Mahendra.
No, my lord, no, my lord, I have nothing against him, my lord. It's
Don't take it serious. Don't take it. So that's.
Obliged, my lord.
23rd February.
writ appeal matters, still number 17. Manmohan PN.
Lords, there are various appeals not which is filed by my learned friend and appeal that is filed by me against the same order. Can I request not that not my learned friend be directed to serve copies of the appeal on me where he has filed? I'll file not serve a copy in him.
Petitions were disposed of as suggested my NITK, my lord, for whom my lord is appeal. My lord, they constituted a one-man inquiry commission to find out what is the solution. The one-man commission, my lord, which was headed by a former director of the very same institute, suggested a solution for which, my lord, the parties were agreeable. And, my lord, the NITK placed that report before the learned single judge. Based on that report, my lord, the matter was disposed of. When a representation was made, my lord, they said, we require the legal opinion of the learned additional solicitor general. It appears, my lord, that also was provided. It is thereafter, my lord, this writ appeal has been filed. My lord, I understand, my lord, the opinion provided by the learned additional solicitor general, my lord, is to implement this order. That's what, my lord, they orally communicated to me. Then, my lord, the matter was placed before the board. My lord, board opined, my lord, that it did not pass any orders. And, my lord, it is at that stage, my lord, this writ appeal came to be filed. Your lordship may kindly see, my lord, if the writ appeal, first writ appeal is dismissed, my lord, I will withdraw all my writ appeals. My lord, without any promotion for the last 14 years, my lord, these two teaching faculty, my lord, are before the court. In every selection, my lord, their case is ignored on the ground that the first selection they had challenged and it is sub judice. My lord, how in a second how in a second selection, a first writ petition filed in 2009 becomes sub judice, I do not. Even though, my lord, they are qualified and eligible, their case were overlooked for the last 14 years. Finally, my lord, a solution was given. My lord, belatedly after 225 or 26 days, my lord, they are in writ appeal. Your lordship, my lord, kindly hear my learned friend. My lord, if there is something, my lord, your lordship may issue notice. Otherwise, my lord, your lordship may dismiss all the writ appeals. Amicably, my lord, on their suggestion, the writ petition was disposed of.
I'm not aware. Lord, may I make a
They have
request?
only a short tenure, my lord. They are at the verge of their retirement without promotion, my lord. One is 60 years, another, my lord, is 57 years.
Lord, may I make a request not? The writ appeals that were filed not by them is of 2023. And then they filed a contempt also. The decision of the learned single judge is not on merits. The one-man committee was constituted not pursuant to a resolution that this honorable court said tried to resolve the matter. That committee report was placed on record, but the board of directors not rejected the committee report. That is also recorded by the learned single judge.
You are for institute.
I am for
And
the
for the institute.
professors, my lord, assistant professors.
But IAP for the
Only two professors, my lord.
Appeal is by
Yes, Lord. One appeal is by the institute, not for whom I appear. A learned friend appears not in the other appeals, not where not it is not challenged not by the employees.
It is on the suggestion of the institute, my lord, this was disposed of. Your lordship may kindly see the order. And the committee constituted, my lord, by them, not at the instance of this honorable court. My lord, to resolve this, my lord, a committee was constituted by the NITK. My lord, it is headed by none other than the former director of the NITK.
Not, promotion is not a matter of right, not. There has to be a selection. Selection committee has to take a decision. On suitability, not promotion is given. Therefore, not, if my lord, not direct, not both of us to exchange not a pleadings. Therefore, not will be complete with all the pleadings. Then not I will not argue on the merits. Because all his appeals, my lord.
My lord, if my learned friend is going to
if I can
implement it, my lord, I will withdraw all my writ appeals.
Lord,
Let him put it to the NITK, my lord.
Lords would seem not the order to learn it single judge. The reasoning given is not, it will put a quietus and the matter is closed, saying that not, although the Board of Governors not rejected the report of the one-man committee, the learned single judge says this will put a quietus to the matter. But not the selection not or promotion can only be done not by the selection committee. And it is not a matter of right not that they can seek for promotion. In fact, Lord, when he was given Lord a regular Lord increase Lord of AGP, but that Lord he rejected, saying that not he has to get extra amount. About 7 writ petitions that he had filed before this honorable court on various grounds. But can I just perceive not, so please see page 67, Lord, the order of the learned single judge. But I did not appear before the learned single judge, Lord, but the order, Lord, does not say, but it is on the basis of, Lord, consent. In fact, Lord, please turn to page 67, para 9, Lord. May I read, Lord? Para 9, Lord. However, at this stage, it is pertinent to notice that in order to bring a quietus to the litigation pursuant to the interim order passed by this court in this batch of writ petition, Institute had appointed Professor so-and-so as the inquiry officer to consider the grievance of the petitioners and submit a report. Professor so-and-so Naik accordingly had considered the grievance of the petitioners. In respect to the grievance of Dr. So-and-so, Sudhakar so-and-so Naik proposed the following solution. Solutions, not I'll skip that portion. Para 14. Since both the petitioners have agreed to the solution proposed by Professor Sudhakar Naik, in my view, without driving them to further round of litigation, it would be appropriate to direct the institute to accept the solution proposed by Sudhakar Naik, as this would tantamount to mutually agreed solution between the parties and the institute. This mode is required to be adopted in order to ensure that petitioners who are academicians are permitted to get on with their academic and professional life instead of pursuing litigation, which would be fruitless for both the institute as well as the petitioners. Therefore, direct institute to implement solutions which has also been agreed upon petitioners and take appropriate action in the matter. Having regard to the fact that petitioners are litigating near litigate, it would be appropriate institute to implement the above direction within a period of 3 months. But this is the order. Now, my lord, in fact, in the previous portion, lord, the learned single judge also notices that the board of governors refused to accept this report.
What is your grievance?
But my grievance is not. They are seeking for promotion, not as though it's a matter of right. Not, it is not a matter of right. Lord, and their selection not has to be the selection committee. One, not suitability.
What is this Sudhakar's resolution?
Not, Sudhakar's report not was a one-man committee, not which was constituted not to see if not matter can be amicably settled. But that report not was rejected by the board of not governors, which my lord should kindly turn to para 8, where at page 66, my lord. But the bare grievance was not, they're not being given promotion and somebody else is promoted. Some petitions are filed challenging not promotions not given to others. Some lot where representations are given saying that plot selection has to be done insofar as he is concerned, he has to be given promotion. Now, the entire tenor of the order learned with single judges, but on the basis of the decision lot of or the recommendation lot of the one-man committee. But he is not the person who is competent to say that no promotion should be given. And this will not affect not even others who have already been promoted.
My lord, Mohan,
Please,
see,
please.
they have been making necessary applications for them to be considered for the post of professor. Okay. The finding of the learned single judge is that you refuse to consider them for the post of professor only on the ground that they had filed writ petitions against you and no other thing, which you did not oppose before in the writ proceedings.
But yes,
And then you appoint a single man's committee and he gives a report in their favor.
my lord.
I mean, reading of the entire judgment reveals that the only ground on which, yes, what the proposition of law canvassed by you is correct, may be correct, but the point is, you have refused them to be considered for the post of professor only on the ground that they have approached High Court. That's the reason you're not considering and nothing else.
But
That action of yours cannot be upheld. And this looks like a case of victimization.
no, no, it is not so, my lord. May I just
My lord,
point out
may I
what
make one
happened
more
was-
submission, my lord?
Lord, kindly
Board resolved to implement it. Your-
Yes.
If my lord should see, my lord, the cost title to the writ petition, please see, my lord, how many writ petitions he has filed. In fact, my lord, my lord, we had also suggested that be given, my lord, the AGP of not from 8,000 to 9,000, which he refused. He gave a representation saying that don't implement this. Then he files a writ petition. But there are almost 7 writ petitions that he has filed. And this is a confusion, Lord, that is created. Therefore, the committee said, if there are so many petitions filed and he has challenged, Lord, the promotion of other, Lord, professors. That is why they said the matter is sub judice. Once a court decides, then we can take it forward. Now, Lord, I can understand, Lord, if the order is in the merits of the matter. But, Lord, on the basis of a report of a committee, Lord, of a single man committee, Lord, in fact, the committee, Lord, recommendation is as a one-time concession should be given. But kindly see, Lord, the recommendation at page para 10, Lord. It is that some concession has to be given and not ultimately at para 10, not the committee's recommendation insofar as not one of the respondent is concerned is since flexible staff structure is in vogue, MAH may be selected for professor post with financial benefits from 2017 by another selection committee with predetermined terms and conditions. He should be made to withdraw all writ petitions unconditionally. This is a recommendation not of the one-man committee. Now, ultimately, Lord, it has to be by the selection committee and the board of governors Lord, should accept Lord, what is stated. Otherwise, Lord, it will have far-reaching consequences. And that is why Lord, Ministry of Education said Lord, this order has to be challenged.
My lord, your lordship may kindly see, my lord,
Lord,
the resolution. My lord, your lordship may kindly see, my lord, the resolution of the board. My lord, I have produced, my lord, in my contempt petition. May I just read it, my lord, if your lordship permits?
The writ petition, objections in your.
Please note. When the my lords are seeing Lord writ appeal number 1051, Lord.
1051.
Please note. That note would get it not at page 170.
That one-man committee report is of Sudhakar.
Yes, yes, my lord.
But this committee was appointed at your instance also.
No, no, my lord, it is at their instance, my lord, not at my instance or not at the orders of the court.
Both.
Not, my lord. They appointed a committee. The chairman appointed a committee. We were asked to appear, not at our instance. My lord, the board resolved that it may be implemented. Your lordship may see, my lord, in my contempt petition, I have produced that document. May I read, my lord, one sentence? The board of governors noted the contents of the agenda. The director, chairman, and few members of the BOG felt that the court order may be implemented and matter be closed. The ministry representative opined that the institute must obtain legal opinion in the matter and file an appeal if required. My lord, then they obtain a legal opinion, my lord, from none other than learned Solicitor General of India. My lord, it is with them. Oral instructions to me, my lord, is that it is in my favor. It is thereafter, my lord, they have preferred this appeal. My lord, one is 60 years old, another, my lord, is 57. Now, my lord, they must have. And 14 years, my lord, they are litigating. My lord, that board resolution, my lord, I have produced in my contempt petition.
What do you mean by AGP?
That is grade pay, my lord. Additional grade pay or some such thing. My lord, it is not a promotion as such, but my lord, the pay of the promoted post, my lord, is granted.
That is
That
academic.
is something like career advancement, not against vacancy.
Is academic grade pay, my lord, that is given to them. That was provided to him also, which he refused to take it. But what was given to him, he refuses to take it. He gives a representation saying that I don't want it. Can I request my lords to kindly turn to page 21 of not the objections filed my lord in the contempt page, the counter affidavit filed in the contempt. But can I request my lords to please turn to page 21 for a moment?
This one-man committee was appointed your instance.
Not it is appointment, not, there's no dispute about
It
it.
is rejected the claim on the ground of pendency only.
Not, the difficulty is this, my lords are absolutely right. Committee is constituted, he is was the former director of the company, of the institute, etc. Ultimately, my lord, when my lord, it is an institute of excellence, my lord, I have to my lord, follow the procedure prescribed. Not I cannot give a go by and say, I will accept whatever one-man committee says.
Then have
Because
you
it's a
got
board
the-
of governors, my lord, which has to decide it and accept it. Because ultimately, my lord, what will happen is, my lord, if I accept not a one-man committee report, my lord, it is only a suggestion, it's only a recommendation. It is not binding on me. Ultimately, my lord, board of governors has to decide. The difficulty is, my lord, selection is to be done by selection panel. My lord, one-man committee, my lord, is not a selection committee. And therefore, my lord, one-man committee, for example, my lord, somebody conducts an inquiry. A report will be given. But that report, my lord, is not binding on me. Ultimately, my lord, it is the, my lord, the person who is in charge of the affairs of the institute has to take a decision whether to accept it or not. But please turn to page 21, my lord, of the counter affidavit. May I, my lord? My lord, should turn to, my lord, above para 2, my lord. I'll take my lords to the para 1 itself, my lord, to consider the order dated 25/9/2023 passed by the Honorable High Court in WP number so and so. But the next paragraph, the director shared the legal opinion of the Additional Solicitor General of Karnataka that the institute should abide by the final order so and so. 7 months have elapsed since the judgment and the institute has received notice from the counsel with the complaint about filing of the contempt petition. After discussion, the following resolution was passed. BOG decided to appeal against the matter as the institute's counsel representation in the court that one-man committee is acceptable to the institute was actually incorrect, resulting in ex posto selection of a faculty to a higher post, which could have been done only by an academic committee of technical experts after examining his academic and research credentials. But it's an educational institution. But I have to select not persons on the basis of not their academic qualification, not their suitability to the post, etc. But it cannot be done not as a matter of right. And that is why not we have a difficulty not in accepting what has been ordered by the learned single judge.
Your Lordship, may I kindly see my lord page 93 of the contempt. I have produced the resolution.
If I'm not, he is seeking something, Lord, which he is not entitled to in law. I'm not, my difficulty is, Lord, if I accept someone who is not suitable to the post merely because the one-man committee reported.
We are trying to make out from what is suggested, the solution suggested by the committee. And you have to go on a single and get it clear. We are not entertaining.
Please, Lord.
Ask for that. Do you have this National Institutes of Technology Act with you?
My lord, it is in one of the writ appeals I have produced, wherein, my lord, a committee is required to be constituted under statute number 23.
So that is what my brother is.
Yes,
My lord, it
constitutes
requires representatives of the Senate and representatives of the board. In every,
One member committee.
No, Lord, there is no one-member committee. To my knowledge, Lord, it has to be a selection committee which is constituted, Lord, by the board.
my lord,
So that. You don't have the act with you?
Lord, this is the 2012, Lord, I think there's subsequent amendment.
No, National Institutes of Technology Act 2007.
I have not, it's 2012. But I'm told that there's a subsequent change.
WBA 1419, my lord, I have produced.
Therefore, I said, if I'm served with the papers of what my learned friend has filed, not, I've been in a better position to assist the court. Yes, not his appeal, not I have not been served with copies, not norm, not. They're all clubbed together.
WP, it's in WP.
Please note.
It's in WP is straight.
Unfortunately, I did not appear before the learned single judge. Not I have the papers relating to only these two matters.
Page number 137, my lord.
The one only.
2007.
2012 amendment added. Hmm?
Which provision?
NIT.
Okay. 29.
One member appointed by the institute. It is referable to this. Section 29 also your appointment.
Yes, so it becomes final when it isn't good. Now we have to only go through whether the person was appointed in the section. And then, do you have that appointment order of that particular individual? That one member committee appointment order? Sudhakar Naik.
My lord, I don't have that, my lord.
But I'll have to verify and place it. But in fact, it was
My
only
lord,
for
he was
resolution.
appointed by the chairman, my lord.
Exactly, if it is under section 29, it's binding on both of you. That's what the provision says.
By the
My
visitor.
lord, I don't have access to that.
It must be in the name of visitor.
No, Lord, it was only
Order
to,
of visitor.
but it was only, Lord, to resolve, to see if something can be done. In fact, Lord, I think it is there. But in
order to
this
resolve.
produced along with the memo before the learned single judge, Lord. It is not a part of the writ appeal papers, I think.
In order to resolve what?
Lord, it was not,
Resolve the controversy.
this is the report, Lord, which says,
No, appointment.
not appointment.
So any dispute arising out of a contract between the institute and the employees, at the request of employees concerned, or at the instance of the institute, be referred to a tribunal. So it covers, it has the, what
but
you have
this
done is, it has the backing of section 29,
This is not done, not.
and
I
it
think
must be under
7,
section 20.
Step 7, not, can I just pass on a copy?
Not expressly, so we deem to be in the.
Please note.
Presume that
Please note.
if your exercise of appointing Mr. Sudhakar is not, you are saying that it is not expressly under section 9, it is deemed to be in the section.
Not the,
And we will treat it under section.
but can I just not put it this way, Lord? The report, Lord, I think this is the copy, Lord. I'm sorry, can I just have one copy? Can I pass?
Yes, yes, pass. It refers to section.
It refers to section 29. It's binding on you. The decision is
Lord,
binding on.
Can I just not put it this way, not the reference note that is made, but you should see if not there can be amicable settlement. Lord, it is not a selection, Lord, because not that is what the learned single judge also observes.
Expressly under section 29. Your own communication.
But it's a recommendation made, not subject to the report of the subject to the decision of the Board of Governors.
As envisaged under section.
Lord, can I just persuade Lord also see, Lord, the report that he has forwarded, which is in the next page. Lord, he makes a recommendation. Lord, he doesn't pass not any decision, take any decision. It's a recommendation. Lord, very next document, Lord, is the report. In that report, Lord, he says it is subject not to the decision of the Board of Governors. Ultimately, it's the Board of Governors who have to take a decision. Now, Lord, to displace someone else, Lord, and to place these people, Lord, in a different, Lord, post would be difficult. Lord, I understand that, Lord, non-consideration because sub judice may not be appropriate, but however, Lord, it was because of the multiple litigations that were there. Ultimately, Lord, the manner in which, Lord, I'm required to not administrate my institute, but I have to follow the procedure. Otherwise, tomorrow, Lord, there'll be fingers pointed against institutions saying that, Lord, you have not followed the procedure. It has not been done in accordance with law. This one-man committee, Lord, was not a committee for the purpose of, Lord, deciding the matter on merits. Lord, kindly see what he recommends. But manner in which not the appointments have to be made. But there's a notification not of the central government with regard to not how not appointments have to be made. But can I just pass on not this notification central government which I have to follow not for the purpose of not appointment or promotion? Not can I just pass on this not? There is a selection committee not which should consist not of the directors, not visitor nominee, 2 nominees of the board, 1 being an expert, 1 expert from the Senate, not from outside the institute. But can I just pass this on not? Therefore, but I have to follow this not procedure, not to either not provide for not appointment or not for promotion. And not he is claiming it not on the basis of a matter of right, not which is not available to him. And the one-man committee is not the basis on which not I can take a decision. Can you just persuade not so kindly see not this? May I pass this on, Lord? Can I show the notification, Lord? Court officer. A memo ಕೊಡ್ತೀರಾ? But even Lord, if Lords would see section 29, Lord, which my Lords were referring to, not there, the requirement not is any dispute arising of contract between an institute and its employees. At the request of the employee concerned, let the instance institute be referred to tribunal of arbitration consists of 1 member appointed by the institute, 1 member nominated by the employee, and an umpire appointed by the visitor.
You also filed appeal?
My lord, I have filed, my lord, because they were not implementing it.
But
My
he has
lord, then
filed
all the
4, 5
selections, all
appeals.
private parties, my lord, were parties to the writ petition.
Why you should file?
My lord, I will withdraw them, my lord. If his writ appeal is dismissed, my lord, I will withdraw them.
Lord, can I just? But he has filed an appeal before I have filed an appeal.
If you withdraw, will dismiss.
But he has filed the appeal in 2023, Lord. Can I just personally want to kindly see, Lord, this notification central government?
Mohan,
Please, Lord.
in the interest of everybody, all of you withdraw the writ appeals.
But can I seek instructions, my lord? Because, my lord, it's a government, my lord, of India, Institute of, my lord.
Ask them to be fair. Ask them to be fair. See, section 29 clearly stipulates you have the power to appoint one arbitrator to resolve the dispute.
No, my
It
lord.
is, yes,
Can I just person kindly see the provision? my lord?
it is you who have appointed him under
My lord,
section 29.
Lord, can
Okay,
I'll just,
he goes into it and he says they deserve to be appointed as professors. They deserve to be appointed as professors. And the reasoning given by your board, at least in one particular individual, is he is eligible to be a professor, but unfortunately, he has filed a writ petition because of which we are not considering him. What type of answer is this?
not what has happened is, not he has challenged, not all these, not,
You should be graceful enough.
not I'll seek instructions, not. But
For an
can I just
institution.
request, not please turn to not clause 29 for a moment, not.
No, both way can't be done. We are going to dismiss right now.
But can I request, not please turn
We have very good, solid, succinct ground of section 29.
not, can I just,
As of you acted to appoint Mr. Sudhakar as one-man arbitral tribunal. And that is clearly referable to section 29. You are bound by it.
not, can I just request, not,
Simple thing, nothing more, nothing
not,
less.
can I just request, not please see not 29 for a moment, not.
We have seen. it.
Not 29 not consists of not 3 members that has to be constituted. Not any dispute arising out of a contract between an institute and any of its employees shall at the request of the employee concerned or at the instance of the institute be referred to a tribunal of arbitration consisting of 1 member appointed by the institute,
You agreed.
1 member of nominated by the employee.
Agreed for Mr. Sudhakar Nayak.
Not it was to see, Lord, if I can resolve it. But kindly permit me just pass on this notification central government.
Go before Lana single judge, withdraw the appeal.
Lord, can I just request, Lord, please see the notification central government as to how, Lord, promotion has to be done.
Dismissed.
Lord, can I just request, please see.
Dismissed
Lord,
and the other appeal will not survive.
Machan.
We'll toss the order. Yes.
Lord, can I seek one indulgence, Lord? My apologies. Lord, can I just request, Lord, please see, Lord, the notification clause 23, Lord, provides that, Lord, it has to be only by a selection committee, Lord. Lord, I cannot, Lord, do anything contrary, Lord, to this, the notification central government. And that is why, Lord, I am before my lords. Might kindly permit me just show this one notification, then I'll leave it at that, Lord. Can I just personally kindly see this notification? My apologies, Lord. I'm sorry, Lord, there's only one copy. Lord, I was under the impression that
You are withdrawing or not survive?
My lord, if theirs is dismissed, I will withdraw it.
You have done it.
I am withdrawing it.
Lord, please
Yes,
see,
what
Lord,
you-
clause 23, Lord.
Clause 23.
Please, Lord.
Then you go before Lana single judge, get it clarified. Say this is a mistake. That the scope of the inquiry by one-man committee is not as you envisage or you contemplate.
My lord, if 23 is followed, my lord, all selection will have to be set aside because the selection is made by a committee which is not in accordance with 23.
My Lord, in that event, my lords may at least reserve liberty for me to file a review petition with a single judge. My lord. Because not my difficulty is not I'm an institute. I'll have lot of
Some amount of submissions, learned senior advocate Mr. Mohan seeks permission to withdraw the petition stating that the appellant would opt to file a review petition, full stop, without expressing any opinion or merits about such recourse. The appeal is permitted to be withdrawn and disposed of accordingly.
My lord, contempt is there, my
In
lord.
view of the disposal of the writ appeal number 1051 of 24 filed by the institute, learned advocate Mr. So.
My lord, they do not survive, my lord, your lordship may say.
well, Leonard Fendi said he's going to withdraw it.
Does not press.
Does not press for the time being, my lord.
All are time being. We all are time. Does not press the appeal number so and so, it is accordingly disposed.
My lord, contempt is there, my lord.
Lord, may grant me some time, Lord. I'll file a review before the single judge, Lord.
And the order in contempt petition.
Your lordship may defer it, my lord, by 8 weeks or so.
You have the disposal of the writ appeal number 1051 of 24 and the other number
Last number, my lord.
70. What is the other appeal number? And disposal of 1051 as well as writ appeal number so and so 24. The present contempt petition will not survive for the present and it is disposed of with an observation and direction that the appellant institute shall, as per its statement, approach learn a single judge. And so, all right, that may be better. So appeals are disposed of, contempt petition shall be listed after 6 weeks.
Grateful. Obligements.
My lord,
All
May-
appeals are disposed.
my lord, may make one submission. My lordship had suggested, my learned friend, that to gracefully
We have
implement.
not suggested anything. We have suggested that we are going to dismiss the appeal.
My lord, they are at the fag end of their service, hardly 1 year for one person and my lord, 2 or 3 years for another.
If somebody wants to withdraw, we can't help. We can't improvise over that. That is the ultimate thing for the court and for them. No further observation, improvisation.
My lord, it is on their suggestion, my lord, that order came to be passed by the learned single judge. They
What-
said,
So
let
what do
it
you
be.
want?
my lord, I appeared, my lord. By the suggestion of the learned counsel, my lord, who represented the institute, they suggested that this is the report. My lord, your lordship may not record that I am conceding. Instructions
Nothing
are
is
that, my
record-
lord, as per the report, it may be disposed.
Nothing is recorded except withdrawal. And you are not pressing. And the contempt will be listed after 6 weeks.
Yes.
Anything here?
Great. Can I take back? Can I take back the memo and
Get
grateful?
your papers are there? Yes. So when
Obliged.
5-1 is disposed of, then there is a delay. Maybe withdrawn, okay, great. CH disposal. 17.2 is also disposed of, only contempt will serve.
But there are two writ appeals, not whether
Both will go.
there are two writ appeals filed by not institute.
Both.
Question number 18 to Omkar KB. For the respondent statement.
17 and 17.9 will be withdrawn. As dismissed as withdrawn. Rest will stand disposed. As not pressed.
Question number 18 to Omkar KB.
18 for respondents.
Number 18
Pass on.
to number 19 to Rajeshwar PM.
Here for the appellant, that's the notice in respect of respondent number 2 and 3 is still awaited.
Awaited. 2 and 3. Who are 2 and 3?
He's the complainant.
Private resident of the State National Highway toll
Please, ma'am.
workers union
The necessary parties.
and the project director.
No, man, I don't appear.
Since notice,
I
appear for only
respond number 1. I appear only for respond number 1.
notice is not served on respond 2 and 3. We must stand over to 5th March. 5th March.
Okay.
No. So in first matter, first is what? Writ appeal 1727. 1727, 24, since in other cases notices, there's a notice renewal on same date. Any others, since in other matters, as the service is not affected on number 2 and 3. Stand over to. Same day.
Still number 20.
Lord's permission.
Aditya
My
Chaturvedi.
lord, there's an issue that arises under the Standing Orders Act. The appellant before my lords is an employees union.
What about delay?
Please, my lord.
Delay of 26 days.
Please, my lord, there's a delay of 24 days from the first order. I would only request, my lord, the issue is this.
On non-consideration of the interim order by the learned single judge, my lord, they
Yes.
are in appeal.
So what has happened, my lord, is under the Standing Orders Act, the certifying authority, while exercising jurisdiction under Section 10, granted my request that based on judgments of the Honorable Supreme Court, the age of superannuation must be increased from 58 to 60, because this is a highly mechanized area in which the company is involved. The company preferred an appeal before the appellate authority under Section 6 of the Act. And under Section 6 of the Act, the appellate authority has a very limited scope of either modifying or adding some conditions to a decision taken by the certifying authority. Instead, what the appellate authority does is that it records a finding saying there is no hazardous work involved. But nevertheless, in the interest of efficiency, the age of superannuation must be reversed, practically setting aside the certifying authority.
The order you are challenging.
My lord, the orders under challenge is the non-consideration of my IAs. But my lords may have.
Non-consideration of the interim order, the learned single judge. Matter is.
My lords, the issue is this, my lord.
Where is that order?
Please, my lord, the order is at page number 47. Where my IA was listed for consideration, but the learned single judge declined consideration on the IA and said the matters would be heard on merits. Thereafter, the matter was listed again on the 7th of November, which is at page 49. Again, my lord, without consideration of IA number 1 of 24, which was pending, the learned single judge ordered that the matter will be taken up at a later stage. The difficulty I'm facing, my lord, is that during the pendency of this writ petition, there are employees who were to retire at the age of 60, who are being forced to retire now at the age of 58. An identical petition is pending before the learned single judge, where an interim order has been passed, saying parties won't precipitate the matter.
By IA, you want to extension of.
I'm only saying let them not forcefully retire someone while the petition is pending. And there's a similar order passed, my lord, in a similar petition. I'm just sharing that with my lords.
The present appeal is directed against the orders passed by learned single judge, whereby the hearing of the interim application and the pending writ petition has been deferred. 2 different dates, full stop. The grievance of the appellant petitioner is that the prayer in the IA is for permitting the employees concerned to continue beyond the prevalent retirement age
Of 58.
of 50 years, full stop.
58, my lord.
58 years. The employees seek the retirement at the age of 60 years
Please, my lord.
under the standing orders.
Please, and it had been allowed, which the appellate authority has not.
Mere deferring the paragraph, mere deferring of the prayer for interim application does not give cause of action for preferring the appeal, full stop. The appeal is misconceived, however, it is expected that the learned single judge will take up the interim application and decide it in accordance with law expeditiously.
Would my lords just observe, liberty is granted to move the single judge for consideration because some of them are retiring later this month.
It will be open for the appellant petitioner to request learned single judge for expeditious hearing.
I'm deeply obliged, my lord.
So 21 urgent. Still number 22. Mr. P. Anand.
Appellant counsel. It's a matter where, lords, proceedings were initiated against me for disqualification. Decided by the authority holding that there is no ground for disqualification. Appellate authority reverses it. This honorable court, my lord, dismisses their petition for disqualification. Again, on the same cause of action, one more notice is issued. That is called into question before the learned single judge. Learned single judge says, my lords, I refuse to interfere. No discussion on this aspect at all. But the solitary ground on which the writ petition was filed was in respect of the same cause of action for disqualification decided by the authority confirmed by this honorable court on an earlier occasion. May I request lordships to kindly see the earlier decision made notes by the at page 50. The earlier show cause notice is at page 43, decided at page 50. The operative portion of the order, lordships will kindly see page 59. The ground was that I had taken loan, of which I was a partner of the firm. Therefore, and that I had become a defaulter. Therefore, I was entitled for, I was liable to be disqualified. First respondent has stated in their argument that Amaravati Enterprises, the partnership firm, had retired from the partnership before the bank elections. Additionally, the branch manager of Tumkur Green Merchants Cooperative Bank Limited, Mandya branch, informed the petitioner through a letter dated 14/7/2021, stating that the first respondent was not a defaulter. And this was also communicated to the office through a letter dated 10/8/2021. May I request now lordships to kindly turn to the next page, the finding recorded by the authority. Since the petitioner failed to provide any evidence to support the claim of the first respondent, being a defaulter after the election, and considering that 29C does not apply to the pre-election allegations, the request made by the petitioner is not upheld. In the light of the above reasoning and considering the failure to substantiate the defaulter claim, the court has decided to reject the petitioner's request, and as per section 20C of the Karnataka Cooperative Societies Act, it is deemed appropriate to discontinue further proceedings. But the complainant filed an appeal as against this order before the appellate authority, and an order of stay was granted by the appellate authority at Annexure D, page 66. As against which the order of stay is at page 70. The appellate authority, the order of the interim application, but being aggrieved by that, a writ petition was preferred by the before this honorable court at page 71. Page 71, writ petition is filed. This honorable court allowed my writ petition at page 77 and held that appeal was not maintainable, thereby restoring the original order.
Writ appeal by the present petition.
Writ petition by the present petitioner, because against the order of grant of stay.
Okay.
At page 77, learned single judge upheld, allowed the writ petition holding that appeal was not maintainable, restoring the original order of closure of 29C. But in some sort of, some sort of a witch hunt against me, yet again, same notice is issued. That is called into question before the learned single judge at page 82.
Same, madam.
Same. Now, what the only feeble attempt they make is before the learned single judge is, that is for the earlier show cause notice was for the earlier year. This is for the subsequent year. Now, loan is taken only for only once. Obviously, every year it keeps continuing. My case is I had retired from the firm. That is affirmed by the affirmed with the earlier set of occasion. No discussion, but I'm with great respect to the learned single judge. On this aspect, there is no discussion at all.
So if you are mentioning that this is a notice in repeat.
Second one.
In respect of same cause of.
Same cause of action.
This was concluded by this.
Please.
Then no reason is not a good ground.
No, but no reason in the sense, but I would only put it across in this, our solitary ground on which.
Urge a best ground.
Please.
No reason is not a ground.
Very
Once you are right. Yes, what about,
My
we'll come to that if there is some answer from.
Please, my lords, learned senior counsel.
Now it remains a pre-election loan.
Yes. Now let's.
It is a show cause notice, my lords.
No, the loan
A loan was pre-election.
Loan is still
Really?
pending
So
and
that factor continues even.
it
at the time of
continues
section-
and he still continues to be the partner of the firm.
Correct.
Because that was the basis of section 20C closure.
Please.
Please. So now under 29C, my lords, he has to be disqualified if there is a loan. That is the reason. The first, my lords, the earlier notice which was read out to my lords was given by a private party. He gives gives that note, gives a complaint to the registrar saying that so-and-so person is default. Kindly disqualify him under section 29C of the Cooperative Societies Act. My lords, the matter is heard, my lords. The only reason the matter gets disposed of by the registrar is, my lords, page 60, the paragraph. Page 60, the first paragraph, my lords.
60.
60.
Yes.
My lords, it says, since the petitioner failed to provide any evidence to support the claim of the first petitioner being a defaulter after the election. On this ground, my lords, he succeeds. Subsequently, my lords, we get another complaint from the CEO of a society. The earlier was from a private person. CEO of a society gives a complaint that this person continues to be a defaulter and he has to be disqualified under 29C. Hence, my lords, we have issued a notice. And my lords, the challenge is a show cause notice before the learned single judge. Learned single judge, my lords, has passed a detailed order. Looking into the document, my lords, 29C, may I read for my lords' consideration, my lords. 29C of the Cooperative Societies Act. Why a person has to be 29C, my lords.
That way it's included.
The issue is, respectful submission, the issue is not concluded because, my lords, the learned single judge also explains it in the paragraph 4.2, my lords, of the judgment. Why the issue, the same ground was raised before the learned single judge, my lords.
Your cause of action can be somebody's application, which may be made time and again, time and again. You don't revive every time.
Yes, my lords, the earlier proceedings which was concluded was till the year 2021 and he claims that he has resigned in the year 2020. My lords, may kindly see the order of the learned single judge. Section 29C of the Act, my lords. It is not his case that he is not a defaulter. They file an affidavit before the learned single judge that they are a defaulter. Section 29C of the Karnataka Cooperative Societies Act.
29B.
C, capital C, my lords. Disqualification for membership of the board. No person shall be eligible for being elected or appointed or continued. My lords, may kindly mark elected, appointed or continued as a member of the board of any cooperative society if he is in default to that society or any other cooperative society in respect of any dues from him as a borrower. My lords, learned single judge considers this in the order, my lords. The petitioner here, the appellant herein, my lords, files an affidavit to that effect. Yes, he is in due. Para 7 is the reasoning, my lords. Para 7 in page 23. Para 7 of page 23, my lords will get.
Yes.
My lords, page 23, the impugned order, my lords. From para 6, I'll read, my lords. When a show cause notice is issued, this court would not normally intervene in the matter except where the petitioner were to make out a case of inherent lack of jurisdiction. May I read, my lords?
Yes.
Page para 6, page 23. Inherent lack of jurisdiction by the authority issuing the show cause notice. Section 29C of the Act provides for a notice to be issued or action to be taken by disqualifying a person from the membership if a person is a defaulter to that society or any other cooperative society or Sauhardya cooperative society in respect of any dues from him as a borrower. Subsection 1 of section 29C prefaces this by stating that no person shall be eligible for being elected are appointed or continued as a member of the board of any cooperative society. Thereby, it indicates that if there is any default, the disqualification would not only for being elected or appointed, but also from being continued as a member of the board of a cooperative society. This default even taken into consideration with reference to the
Nowadays, this 29C is omitted.
No, 29C is there.
Continues.
It is there.
Continues.
No, 20C. Under it, the closure was omitted in 1998.
20C calculation. No, it's 29C, it's not 20C.
Not
It's 20, there's a mistake.
29C, my lords.
29.
No, the closure was on under which section?
Closure. No, but my case is not that I retired from the firm. That is my case.
No. The learned single judge in the earlier petition rested his decision on what provision?
On the ground, my lord, that the appeal was not maintainable.
Appeal was not.
Appeal was not maintainable, but the original authority recorded the proceeding that I had retired from the firm. I had retired from the firm. That does not change. But now learned single judge records that there is I have stated that the loan continues, etc. That does not matter, my lord. My case is
Madam, we are not able to accept your submission unless you further elaborate.
I will place on record any judgment to that effect, my lords, where, my lords, here it is not a case of the same offense being tried again. My lords, here is a case, it's a continuous cause of action. My lords, and the learned, my lord, the registrar in the first order, my lords, has dismissed it on a private person's
Once the
complaint.
issue is set at rest by this court.
Please,
the
issue
court
is
of-
not, my lords, if,
Cause of
Process.
action dies.
merge.
my lords may
The
kindly,
original order merges with the order of this honorable court.
my
In
lords
fact,
may
lords, I
kindly
was
see
saying
the order.
in Vipul Bhai's case, the honorable Supreme Court lords.
You can't create cause of action by creating.
It
some
is,
application.
my respectful, I bow down to my lords, my respectful submission is there is a complaint by the CEO that this person who continues to be the private party who approached the registrar, my lords, he could not place on record whether he is a partner or not. Now he continues to be a partner and he's continued to be a defaulter and he files an affidavit to that effect before the learned single judge. And it is a show cause notice. He can say all these things before the authority.
We have our own doubt. You can't overturn the decision of the.
My lords, I'll read the order of the learned single judge earlier, my lords. It does not say he's not a defaulter.
Rightly or wrongly, it is circumventing the order
Order of this court.
which is not permissible on any ground.
May I read this? My lords, we have received a complaint saying
Except
that,
appeal.
please,
Okay.
my lords,
Yes.
may I read the order of the learned single judge, my lords? What was, what set asides the original order that is available in page 76, my lords.
We are on 70. Since it is settled.
Since it's settled position of law that the complainant information at the behest section 29C proceeding is initiated has no locus to question the final order passed under 29C, the authority cannot entertain an appeal under the order passed under 29C. If such an appeal is filed by the complainant, in such event, there is no scope to hear the appeal on merits. My lords, here the question of locus, my lords. In this background, if an application is filed urging that appeal is not maintainable, the authority is under obligation to pass orders on merits, and the said application and the authority cannot defer the orders of the application and cannot hear the application along with the merits of the appeal. Hence, the impugned order is not sustainable. Since the law in this regard is well settled, this court does not deem it appropriate to refer the matter to authority to consider the application on these merits. Under these circumstances, the following law laid down in the aforementioned judgment, the court is of the view that the appeal filed by the respondent number 3 itself is not maintainable. The only ground on which the learned judge has, my lords, set aside the order is he does not have the locus. Now we have received a complaint from the CEO, my lords, who represent the society, saying that this person is under default. My lords, my only respectful submission is there is a default and he still continues to be a partner and he has to explain before the, it's a show cause notice, my lords, at the end of the day. He can explain all these things before the registrar would be my respectful submission.
In fact, in Vipul Bhai's case,
Para 8 of
Two more.
third.
please, please.
So she is trying to contend that earlier was on a technical ground of.
It was not technical. That is the question. But in fact, not the, the only contention I urged before the authority earlier was that I was not a partner of the firm. I was not partner. That has been accepted by the original authority and closed it. Now the question is, my lords, can you come back again and re-agitate that issue?
Tomorrow at 2.
Very well.
We'll just go through.
Very well.
Grateful.
I can add it. Chief, management.
Lords, may I place some judgments regarding show cause notice, my lords?
Judgments may not be necessary, but you
Please.
can bring.
Please.
Number 23.
Appear for the appellant, third respondent's appeal. Lords, 32 days delay in filing the appeal is there, but notice the issue is the
Notice is already issued and.
notice has already been issued. Notice has already been issued. Delay of 32 days. Lords. That is 10th April, the order came to be passed, and subsequently we obtained the copies, and vacation had come, we could not contact that.
IA number so and so so and so. Heard learned counsels for the respective parties. Delay of 32 days in preferring the appeal paragraph is explained in the accompanying affidavit by stating that after the order of learned single judge dated 14/3/24, certified copy was applied. On the same day. He stated by the applicant that his advocate informed him that the appeal would be required to be filed within 30 days. It is further stated that thereafter discussions took place whether the appeal recourse to be taken or not. This recourse to appeal is to be taken or not. Wherever. The applicant has stated that this process of consultation and taking legal advice has resulted into consumption of time leading to delay of 32 days. Paragraph in overall view. Since the time is consumed in the taking legal advice and preparing for the appeal, it could not be said that there is an element of culpability or negligence in the conduct of the applicant. Which cause is made out to be condoned the delay to the extent of 32 days. Delay is condoned, application delay.
There's another kind of
Very
appeal, my lords.
Responded.
What is the matter?
My lords,
Today or
the
any other day?
lords, I am an association registered under the Societies Registration Act of 1960. And my lords, by virtue of the impugned order, I was been called upon to register under the Apartment Ownership Act of 1872 because I am an association which caters the needs of the apartment owners. Lords, my submission before this honorable court, that was, my lords, is based on the another judgment of the coordinate bench of this honorable court, which is at page number 102. My lords, I would submit, my lords, that the association which has been sought to be registered, which has multiple performances under the Apartment Ownership Act, it does not confer a personality on the association registered thereunder. And I cannot perform various acts which I perform, like such entering into power purchase agreement, be sued and be sued. I can do no work over there. And may kindly see the order. Notice I was been required to register under the Apartment Ownership Act of 1872. And that act does not confer personality only on me, on the association. And but still 2018, the government permitted all these associations to be registered.
So what is wrong with this order?
It's my kindly see that it has been based on the order passed by the judgment of this honorable court at annexed H to the writ petition at page 102, may kindly be seen, notes. There the issue was whether that particular society which was in question, whether it had done the activities within the meaning of section 3F of the Societies Registration Act. The court went into that aspect of the matter and held that Societies Registration Act does not cover the issues only relating to the apartment owners, and therefore it is not registrable. And thereafter required the persons to register under the Karnataka Apartment Ownership Act of 1872. Notice here is a society which does, other than the not only the maintenance of the building, it enters into power purchase agreements with the corporation. Anything related to the building, maybe to the apartment, but it does various other acts which is beyond the scope of mere maintenance of the apartment building. Notice Apartment Ownership Act, which is 1872, it does not confer an personality on the associations which have been registered thereunder. Therefore, I cannot do any act except to the extent of collecting and maintaining that building. And that is not the only work that I am doing over there as an association. Therefore, I should be an association falling under section 3FF of the Societies Registration Act and do various acts of protecting the natural resources associated with the building and various other acts. I entered into power purchase agreement with the BESCA. I set up STP, these things, everything that I do, which fall under section 3FF of the Act. And as it does not confer personality on me, I cannot sue and be sued. And again, this act is only optional. In such circumstances, I said that I would request this honorable court to kindly look into the act once, my lords. Lords,
so you are aggrieved only by this paragraph 9?
lords,
Paragraph 9 of the impugned order.
I'm only been agreed by the paragraph 9 of the impugned order, when it said you are required to register yourself under the apartment lodge. I would request this honorable court to kindly look into a preamble of the act for a while, lords, to understand this thing. Lords, an act to provide, may I read, lords?
No, preamble not necessary.
No, application of the act may kindly be seen at paragraph number, section 2 of the act. The act applies only property of the sole owner or all of the owners to which submit to the same to the provisions of the act by duly executing and registering the declaration as hereunder provided. This is only an optional enactment. If we do not submit ourselves over there to this act has no application. Next, may kindly see section 7, the limited personality conferred on the associations registered under this act. My lords, may kindly see section 7 of the act. It confers personality on the association only to a limited extent. Each apartment owner shall comply strictly with the bylaws and with the administrative rules and regulations adopted by the pursuant thereto, as either of the same may be lawfully amended from time to time, and with the covenants, conditions, and restrictions set forth in the declaration of deed of his apartment. Failure to comply with any of the same shall be ground for an action for recover sums due as damages or injunctive relief, both maintainable by the manager of the board of the managers on behalf of the association of apartment owners, or on a proper case, maybe by an aggrieved apartment owner. It's a limited personality has been conferred on these associations. But today, the Apartment Owners Association does not do only the act of vis-a-vis the members. They have set up virtually the solar plants over there in the apartment, because they have entered into power purchase agreements with the BESCAM. They have entered into various STP agreements, maintenance agreements. They do multiple activities virtually.
The owner of the property submits to the provision of this act.
Well, it is only between them. Persona is only between them.
Then what happens to their bound?
What about the third parties, this thing?
My lord, here we need to understand Karnataka Apartment Ownership Act is, let's look at the judgment itself, sir. Page number 24, point number 4, where it clearly says that the petitioner has claimed that the association to be registered under the provision of Karnataka Ownership Flat Act. And accordingly, the judgment has accepted the same thing, and they have been asked to register under the Act in 1972.
They opted.
Yes.
They have not opted.
1 minute. Pardon, sir?
They opted to be registered.
No, we have not.
No,
opted.
you are not up. It is a compulsory on the promoter. It's a promotion of Karnataka Ownership Act, Regulation of Promotion of Construction, Sale, Management and Transfer Act of
Oh, that is in
1972. It is, here it has been termed as the act in the entire judgment. Now, this is where the construction, it is obligation on the part of the promoter to transfer the title. Once the title of the property is transferred to the organization, then they can do all the sort of the work. There is no prohibition. Now, coming to the point over here exactly, sir, this judgment talks about the act is only 1972 as Karnataka Ownership Flat Act. In the section 10 of Karnataka Ownership Flat Act provides a registration for a cooperative society or a company. And the judgment, nothing wrong in this, sir. The only 1960 society cannot carry out the maintenance is all about 974 and other subsequent to be read, and it is the fact like that.
These are two different enactments, my lords. Karnataka Ownership Flats Regulation and Promotion of the Construction of Sale and Management of Transfer Act 1872 is different from Apartment Ownership Act of 1872. Lords, this Karnataka, what he is referring to applies to a different scenario altogether. When the apartment building is under construction, only 7 sale agreements have been entered into. That's a different scenario. Apartment Ownership Act operates on a different position, different field virtually. Two enactments operate in different fields.
The provision of the Karnataka Ownership Regulation and Promotion Act. This
Section 10.
10.
Yeah. My lord, section 10 obligates the promoter to form a cooperative society or a company. Promoter to take steps for formation of a cooperative society or a company. As soon as the minimum, shall I read it? As soon as the minimum number of persons required to form a cooperative society or a company have taken the flats, promoter shall, within a prescribed period, submit an application to the registrar for registration of.
That is under the, that will then.
That's a different scenario.
Cooperative Society Act.
That is
Cooperative Society Act or a Company Act, either anyone.
Not this act, ownership of flats. Act.
Karnataka, sir, the regulation of a construction, apartment will come into existence only after passing through the regulation of a construction. Until the regulation of construction is not met, apartment will not come into existence.
No, registration under this ownership of flat act is not compulsory.
It is obligatory. It's obligatory act. It is compulsory.
Section 10
The-
doesn't, section 10 doesn't say.
Like different scenario altogether.
10 doesn't say so.
It operates in a different field, my lords. That's the problem.
Sir,
It operates in a different field altogether.
No, it do not operate. The purpose of this enactment itself is to bring obligation, and it is a regulatory act. It is similar to that of RERA today.
We'll continue.
McCain.
They have pencils there.
Lordship, if I may. Lordship, we mentioned the matter in the morning. Lordship was quite kind enough to approve that mentioning to be taken up after post-lunch. Lordship may fix a convenient time of Lordship's convenience, whatever deems such. Item 67, Lordships.
They're coming from outside.
Lordships, I'm coming from Supreme Court, Lordships. Please.
Today there is a 2:30 board.
Your Lordship, with your permission, I'm filing a memo for posting for tomorrow, Your Lordship. There's an urgency, Your Lordship. Your Lordship, tomorrow, writ appeal 951 has been listed before this Honorable Court. As per the directions of Honorable Supreme Court in SLA number 14255, it's connected matter, Your Lordship, 949. We are for respondent number 2 in that said matter, Your Lordship.
But before us, what is to be listed?
Lordship,
Before us, what is to be listed?
for clarification, Your Lordship.
Which? Same. How? For different bench, provided bench is constituted. Whenever bench is constituted, your matter, what is your matter?
My matter is writ appeal number 949/2024, Your Lordship.
How it is connected?
It is connected with writ appeal number 951. Tomorrow it is listed, Your Lordship.
Then you file it. Then the registered judicial take call. We don't know whether tomorrow bench is going to be constituted or not. Whenever that matter is listed, we'll see what to do with your matter.
Obliged, Your Lordship.
Lordship, serial number 85 for withdrawal, already filed a memo.
Triple 1928 of 24, Learned Advocate Mr.
Girish S.
So and so for Learned Advocate Shiva Rudra.
Shiva Rudra. Yes, ma'am.
You are yourself Shiva Rudra.
No, I am his colleague.
For Learned Shiva Rudra for the appellant. Files memo dated 7/1/25. Seeking withdrawal of the present writ appeal. Memo is taken on record, wherever the writ appeal stands dismissed as withdrawn.
Much obliged.
23.
My lordship, serial number 39, my lordships. There is a medical emergency for the senior, my lordship. I seek for the adjournment, my lordship.
Which number?
39, serial number 39.
At the request of learned advocate, the petitioner on the ground that learned senior counsel to conduct the matter is in indisposed health from extend over to 21st February.
Much obliged, my lordship.
Serial number 23.
Sir, permit me to put up the position in this fashion, Lord. The construction of the multi-storied buildings in the state of Karnataka are principally governed by two enactments, my lords. One is Karnataka Ownership of Flats, Regulation and the Promotion of Construction of Sale, Management and Transfer Act of 1972. By short, it can be called as COFA. Another enactment is, my lords,
Section 2 of this Karnataka Apartment Ownership Act. Read it, read that.
This act applies only to the property sole owner or all of the owners of which submit the same to the provisions of this act by duly executing, registering, declaration as therein provided.
So,
Owner or sole owner. Now the question comes is, who is the owner of the property?
no, this makes it optional.
it's only.
Yes, sir, it makes it optional. But whereas Karnataka Ownership Flat Act is not optional. It is compulsory. COFA, 1972, again. Sir, there are two acts. One is for construction, promotion and transfer of the title. That is
We are concerned with the registration under this act, 1970.
1972.
1972 Act are two again here. One is for
Two is yes, but we are concerned with this act. 72 only, as far as the learned single judge's direction is concerned.
precisely the learned single judge has rightly passed. He has stated the word in paragraph number 4, page number 24, sir. Karnataka Ownership Flats, Regulation and Promotion, Construction and Sale Management and Transfer Act of 1972. It has been used correctly. So there is no error committed in this order.
May I, my lords? I think that what is
Entire prayer in the petition was based on that 1973.
Karnataka Ownership Flat.
Direction, final directions are also in the context of that act, not this act.
may kindly, it is not. May kindly, I would request this honorable court to kindly look into paragraph number 6 of the impugned order at page number 25. This is based on the division bench order of this honorable court, which held that the required to be registered under the Karnataka Apartment Ownership Act of 1972. May kindly see this. The submission, though noted, is to be rejected on account of what the division bench has in identical circumstances held. The division bench of the aforesaid case has held as follows. That I would request this honorable court to look into paragraph number. It is the case of the appellant that Mr. Value Design Private Limited is a builder and developer, constructed the apartment complex consisting of 6 blocks having 196 flats. The complex has various facilities such as swimming pool, clubhouse, gymnasium, indoor game, halls, parking space, walking space, etc. The case of the appellant is that no steps have been taken to form an association apartment owners by the developer under the provisions of the Karnataka Apartment Ownership Act 1872. But this is what exactly I'm saying is this for this reason. That COFA, whatever that they are referring to, does not apply to the present situation at all, because that applies only, that casts an obligation on the builder to register it when he enters into sale agreement with 7 apartments. May kindly see that COFA for a while, my lords. This cannot have an application to this case at all virtually. This is a completed construction with occupancy certificate where individual members required to submit it to this thing. May kindly see this, my lords. Therefore, whatever he is referring to required to be understood as referring to Ownership Act of 1972 only.
The act has been referred in this judgment is only for the Karnataka Ownership Flat Act,
11 seconds.
not to the
Understand this.
Karnataka Apartment Ownership Act. Hence, it is, order is
That's
right. It is under the Karnataka Ownership Flat Act, where there is a provision to register an association as a cooperative society or a company. Otherwise, in the other enactment, there is no provision to register. My colleague partly is right. It is not a legal entity. Legal entity comes under only Karnataka Ownership Flat Act.
Permit me to complete this.
In fact, these two judgments have to be referred with 1960 society, Karnataka Societies Registration Act cannot carry out maintenance.
The area of operation of this
My lords, area of operation.
apartment ownership act.
It is Karnataka.
No, what is the, how it operates?
May I explain this position, lords, a bit?
Area means not the.
My lords, may I explain this?
Geographical area, the subject matter. How it operates.
Sir, there is no association as such. It is actually an obligation on the
No, why-
apartment
why
owners.
This 2x, this 72x, 272x.
May I make this submission? Lord? May I clarify?
One is for the construction, that is regulation and transfer. Another one is on the apartment owners to pay the outgoing obligations. It is ownership and heritability purpose. Sir, under the Transfer of Property Act, there is no provision to sell undivided share as such. Now, through Karnataka Apartment Ownership Act, partly the undivided share alienation is recognized. Karnataka Apartment Ownership Act has to be read as an extension of Transfer of Property Act to certain extent.
Lords, may I make my submission on law, position of law, my lords? What I understand is.
So the registration under the regulation and promotion of the construction act is under which provision? 10.
Association gets registered under the provision of section 10.
So that is what the direction is.
Yes,
No,
sir.
no. No, it is not, my lords. May I clarify this position, my lords? May permit me for 2
Now,
minutes.
if at all, if it is not so,
Yes, yes, in-
now the petitioner has claimed that it should be registered under the Karnataka Apartment, Ownership Flat Act. And accordingly, the writ petition is succeeded. And association registration provision is available only under the Karnataka Ownership Flat Act. That is section 10. And subsequently, section 11 mandates the promoter to transfer the title interest of the property to the said organization.
My lords, may I clarify the position? My lord, permit me to complete my argument so that he could, what I am trying to submit, that would be completed. My lords, may kindly see the construction of the buildings in the state of Karnataka are principally governed by two enactments. One is this COFA, one is the KAOA. This COFA is, my lords, with the obligate, it is with respect to construction, sale, management, and transfer of the flats. Flat is being defined under the Act as any unit constructed, whether it is residential, commercial, whatever it is been constructed. The obligation under the Act is cast on the builder. The moment, my lords, he executes into 7 apartments, 7 units, he was required to register a society. To society, he will transfer the building. The agreement was required to be registered. Under the COFA, there was no concept of ownership of apartments at all virtually. May kindly see section 11 for a while, my lords. I would request this honorable court to kindly look into section 11 of the COFA. COFA says that once the apartments are constructed, the entire apartment building required to be transferred in favor of a cooperative society. There was no construction concept of ownership of an individual apartment or building under the COFA. This was entire obligation was required to be discharged by the builder. Notes, may kindly see section 11 for a while, notes. I would request this honorable court to. Section 11 of the Act. He was required to transfer both the land and building in front of the society, and individual ownership of the flats were not recognized under the COFA. There subsequently what has happened, a question arose before the legislature whether that individual apartment could be owned, because on Transfer of Property Act, even undivided interest could be sold and apartments could be owned. Then how it required to be controlled was the question. Basically, it was in the context of heritability and transferability of those apartments. May kindly see the preamble of the Karnataka Apartment Ownership Act of 1872. That is, the law said it is expedient to provide for ownership of an individual apartment in a building and to make such apartment heritable and transferable property and to provide for matters connected therewith. This was the question that was there before the legislature. Then legislature came up with another enactment to say you can own an apartment, and if you own an apartment, you can subject yourselves to the particular this act. If you subject yourselves to this act, you are going by so and so provisions of the act. If I don't subject myself to this apartment, even then I'm an owner of an apartment. I can own an apartment by getting into sale deed executed in my favor. Then what happens was the question. Lords, till 2018, state government used to permit all the apartments to be registered under the individual units be registered in the respective name, and common facilities be maintained by an association formed under the Societies Registration Act. In my lords, in the division bench of this honorable court, which I have said to this honorable court, has seized with the matter, wherein in case of an association, a question had arisen.
Objecting this, why should you not register under the Act?
My lords, there are 2 points that I am trying to convey. The KAOA Act does not confer personality in an association. That is the main problem. I don't only collect the monies from the apartment owners and accountable only to them. I enter into power purchase agreements. I enter into maintenance agreement. I enter into various kinds of agreement being an association. This act does not confer on me the personality. Basically, that is the problem. And as it does not confer on the personality on me, I cannot sue and be sued. I am like a partnership firm. Every time when I sue, I require to make all the unregistered association. I require to make all of them members the party. This is the problem.
For whatever purpose is this Regulation and Development Act of 1972 operates, you should get yourself registered with.
Now it is not possible because this is a situation. That's what exactly I'm trying to submit. COFA applies to a case where promoter was required to do various acts. May kindly see section 5 of the COFA for a while. It is not possible at this juncture. That's why that's the problem that I'm facing with. I would request this honorable court to kindly look into section. If it was possible, I would have registered over there. It's not that I have some problem over there in registering it. May kindly, my lords, I would request this honorable court to kindly look into section 3 of the Act, general liabilities of the promoter. Notwithstanding anything contained in any other law for the law, a promoter who intends to construct a block or a building of flats, all or some of which are to be taken or taken on ownership basis, shall in all transactions with the persons intending to take or taking one or more of such flats be liable to give or produce or cause to be given or produced this information and documents hereinafter in this section be maintained. After which is, my lords, I would request this honorable court to kindly look into section 5 of the Act. Section 5 of the Act provides how an agreement required to be entered into. promoted to maintain separate account in sums taken in advance and deposit trustee therefore and disturbance of the purposes of which is being given. This, he will accept the monies only as a trustee. Subsequently, under section 10, he forms a society. 11, he transfers the entire property to society, including my flat. I don't own a flat in case of a flat owners association. But kindly say section 11 for a while. I don't own an apartment in the situation. These acts are not exhaustive. That is the complication that is happening over there in the process.
It is a,
One second, I'll complete it. Then you will argue that.
Now, counsel,
Kindly.
COFA, is it applicable to commercial premises also?
It applies to commercial.
It applies.
Definition of flats mechanism. Flats has been defined under the act.
Yes, this one. But whereas apartment ownership act, it applies to
Only residential apartments.
residential apartments.
Residential apartments. And COFA applies at a situation pre-completion of the construction. But section 4 says the minimum number, it is pre-construction of the construction.
Here is this land.
May kindly, Lords. May Lords, have sought the stay only to that extent. Permit me to collect the maintenance charge. I require 1,690 apartments are there. And I require to maintain every month the building. And if I'm been prohibited from collecting this thing, I would be in a very difficult position. And if this court requires, everything has been audited, completely audited. I can submit the accounts to this court even. I have no objection to that.
my lord, cannot be granted at this stage because the society is already passed whatsoever it may be. And secondly, already they have a direction from the registrar not to collect the maintenance charge and everything, which they have not challenged. So hence, at this juncture, it is not appropriate for the court to permit them to collect the maintenance. And page number 100 and 101 is a translated copy.
I will maintain this under the court guidance. I have no objection. I'll submit all the accounts to the court regularly. I have no objection on the matter. Because otherwise I cannot run day month-to-month
No,
activities.
the date may be given and disposed of at the.
That also will do, but in the meantime,
I kindly.
See, registration can't happen under COFA. It has to be under Apartment Ownership Act.
There is no provision to register an association under Apartment Ownership Act. Even though in previously 974, they say, a previous writ petition says, those are all per inquirium orders. These are orders but cannot be enforced in any manner.
Scope,
There is no provision to register an association.
In the neither of the two acts, there is a
provision, correct, my lord. It's not complete, they are not exhaustive.
Karnataka ownership, sir,
Not
it is like
exhaustive.
this.
It is
It
only
is a property and a
Yes.
collective ownership has to be achieved.
probably doctrine of election, namely choice of
Okay. Yes.
No,
others or
My
the-
lord, it's not exactly the choice of, even if I say the government further, they have issued a circular with this effect also. In the year 2005, I will submit all those papers. Even if a property is owned by obtained transfer by the cooperative society has to submit the deed of declaration and it is supposed to be sold as an individual apartment. Accordingly, Karnataka Cooperative Society Act, Section 38C, I believe. Yes, it has been amended as far as the apartment is concerned. So when the situation is warrants, it's a collective ownership is being held by the association of the property. That is where a cooperative society or a company is required. That is what Karnataka Ownership Flat Act mandates. In fact, today RERA also says that it should be transferred to the association of allottees. So when we are talking about transferring the title, that is immovable property, the association of persons has to be a body corporate. Body corporate means company or a cooperative society. There is no other choice that comes in between. And coming to the Karnataka Apartment Ownership Act, it only gives an effect of individual heritable and transferable position to the portion of a building. When I read the definition of apartment here, it only talks about the portion of building. Transfer of Property Act do not recognize such property in any manner.
Heard all names. This appeal arises out of judgment in order dated, common judgment in order dated 14th March 24, passed by a single judge in two writ petitions, insofar as the decision pertains to writ petition number 19412 of 2021. The issue arises for consideration paragraph is about the registration of the appellant apartment owner welfare association compulsorily or otherwise under the Karnataka Apartment Ownership Act 1972. Law on a single judge has in paragraph 9 of the order inter-alia observed that if the welfare association fails to register under the 1972 Act within stipulated time from any amount collected thereafter for maintenance from the residents of the apartment complex would be unauthorized. Paragraph. In the facts of the case and having heard learned counsel of the parties, the court finds that the appeal deserves detailed hearing, therefore it is admitted. Full stop. Learned advocate for the appellant prays for stay of the operative directions of the judgment and order of learned single judge. Full stop. In this regard, it is observed that it will be open for the appellant welfare association to collect the amount of maintenance from its members. However, the amount so collected will be deposited in a separate account, which may be opened by the association and the
We have an account over
Submission
there.
to make.
I'll submit account.
Submission to make here.
separate account. in the-
Separate account. May kindly be operated, no
account
issue.
To be opened by the welfare association and no amount shall be spent without leave of the court.
No, every month maintenance required to be done, my lords. I cannot come every month to this court.
And then any spending shall be, the details of the spending from the said. account
Yes,
shall be
that time we will
submitted
furnish. May kindly,
Court in the present.
operative, may kindly.
The appeal shall be listed for hearing on 24th March.
24.
My lord, I have a submission to make. Regarding these things, there is a lot of confusion which is going on in the, as a whole, throughout Karnataka. There is a one PIL is pending. In fact, rule is also passed, 511 of 2021. I think if it can be heard, all the cloud that is going on can be.
There are no settled judgments on the
Yeah,
matter. That is true.
settled
That is not
judgment
a.
come. 511 of
Another writ appeal,
2021.
writ appeal number
Connected matters are there in that also.
893 of 2024 is that may be called along with this.
Unless date is given, it may be listed. If date is given, not.
No, it is not given. No, the 893 of 2024.
Stated by Lord.
24.
Writ appeal number.
Common order judgments, the one, two judgments were there, one judgment is that.
Connected appeal, in which note it is given, therefore, the registry may place the said writ appeal also, along with the present appeal
Mechanic.
on 24th March.
There is a lot of confusion and single judge, different orders are coming and it is creating total confusion. So all the cases can be clubbed together and heard,
We'll do that.
or 511 should be disposed of at the earliest of 2021.
So 230 matter, seal number 87.
Service on respondent number 3 is complete, but have filed a memo. Both the time summons as well as on the standing count, not reflected in the list.
So, the interim order was passed here.
Yes, Manoj, interim order was passed.
So then any
On
urgent,
on Monday, Manoj said we are asking for announcement of results, Manoj, of the examinations which are already undertaken pursuant to the interim order.
so today there is no urgency.
On Monday, Manoj, the council is absent because his name is not shown.
NKT.
Then now result will
We-
be announced.
Yes.
We
Let it
undertake
wait.
to file the work
Manoj,
alert, my
and
lords.
Manoj, for conduct of the examination also,
When the next exam is going?
conduct of the examination.
Next examination is going to be conducted when?
No, Manoj, one of the examinations was missed because of the fact that the order under impugned was not released, Manoj. We had filed the appeal.
That is reconducting.
It's reconduct. Look, otherwise, Manoj, if it's not reconducted, I lose one more year. I'm losing the attendance as it's.
But that is not very imminent.
Manoj,
is-
the announcement of results is imminent as well as, Manoj.
No, no, hearing of the petition, appeal.
Interim, Manoj, interim application.
Why?
Manoj, otherwise I will lose out 1 year.
Will take
Manoj, if I don't, Manoj,
13th February.
Manoj, February would be very.
Why?
Because exams, Manoj, university is conducting other examinations in.
You are permitted to appear in the examination.
Yes, sir. The other, Manoj.
Results is going to be declared on Monday.
Yes,
One or two examinations remains
yes,
to be reconducted.
yes.
So it can be done within within what time? Within 1 month.
Within 10 days also.
Why? That is,
If not, my lords, I will lose out on attendance of the next year. Otherwise, I'm not permitted to get promoted to the next academy. I'm awaiting my lords promotion into the next academy.
come on 28th January.
So my lords, on Monday, my lords, on an interim application, I will convince your lordships, my lords, and matter could be.
All right, for the time being Monday.
Obliged, my lords.
My lords, service on the respondent number 3 is complete. Memos filed. To that.
Seal number 67. Is everyone yes?
Lordship, thank you for this indulgence. Lordship, this is a case for contempt and a writ appeal, which has been filed by the petitioner.
Appellant's counsel, my lord. It's an appeal filed by one Mr. Sarvana, my lord. Writ appeal number 1335, he has to present the case. Serial number 67, my lord.
Yes.
The appellant's counsel is not here, my lord. He has to present the case.
But-
My learned friend is for the
We have
complainant.
in 1335, we are the respondents, we are the petitioners in
Have to inform him,
9009
because it's being taken
and
out of-
321.
I
Lordship,
thought you are for the appeal.
He is for the complainant, my lord, in the contempt petition.
in the contempt petitioner, we are the
Then
petitioners.
appeal is pending, appeal you to inform the appellant.
You should
Lordship,
present.
they were supposed to be here, but
Counsels, since you asked for priority, you should have informed the appellant. Sir.
Lordship, we had.
Who appeal?
Mr. One Sarvana appears, my lord, can.
Okay.
You have to inform the council. Appeal.
Please, we inform.
It is your duty.
2:30.
Before booking tickets of the council from Delhi, you have to.
Lordship, it's a small matter.
Maybe, but we'll know in absence of the other side will not take.
We'll just inform Lordship. Lordship, if may pass over the matter, we'll inform the other side and he'll be here.
I
Please.
don't know whether informing at this 11th hour will do. You can do it.
So it's listed, we'll inform.
Now continue with the. So now 51. 51, not to be placed before the bench where one of us into bracket honorable Mr. Am I Arun? Remember.
So passover matter, seal number 11. Gurudev I. Gachinmar. Seal number 11.
This is in the report, lying in my desk. Yeah. You find out our decision which is against you.
Alex?
There is a direct decision that in the matter of allocation of grant to different boards, we will not entertain PIL. It is entirely a different realm.
So the scheme itself is over, my lord.
The direct judgment of ours in the previous.
The
bench.
scheme itself is over for that particular financial year.
Reported
my
in the
lord.
last Karnataka law journal. In the last issue, it is
They have
reported also.
chosen, they have made a pick and choose method, but they have chosen some wards, my lord, there were totally 20.
That is not our subject matter, dismissed. Sorry, it is directly covered. Next.
Seal
Who
number,
appears? Madam, you are appearing.
yes, madam. Seal number 12. Mr. Dhananjay CP, 12.
My lord, in this I'm filing a memo, my lord.
Ah, yes, where is, nobody is there. Learned additional government advocate, Srimati Nilofer files. A memo. Which reflects, according to her, the steps taken by the authority to remove the encroachment near the, what is that, Malla? Near the lake. Malla Shetty, MALLASHETTL, Malla Shetty Lake. The memo is taken record since learned advocate for the petitioner is not present to be listed tomorrow at 2:30.
Seal number 18.
For the appellant, my lord, most
Park
respectfully pray for time.
Infectious. The term of the member is expired. Court remains. That is
My
how
lord, my
done.
senior is unwell. my
Done a
lord.
single is accordingly dismissed the petition.
He'll be personally present here, my lord. My senior is unwell, my lord. He'll be personally present. He could not be here.
Senior may get well soon, but this matter will not survive. When shall we keep, Mr. Counsel? When shall we keep? There is nothing in the matter.
My lord, 2 weeks, my lord. time.
No, not 2 weeks, 2 days.
No, my lord, 2 weeks, my lord. Please, my lord.
5th February.
Obliged, my
We listed at 2:30. Looking to the compass of the controversy.
Still number 24. Ajay Jain.
Lord, your lordships have passed a very detailed order, my lord, when it had come up on 28/10/24. Lord, noticing that this is a demand made without an assessment order. Your lordships, my lord, had stayed that condition of 25% deposit which the learned single judge had granted. That order had been continued. Not
Again,
the
make
writ petition
one
could be heard and disposed of, my lord, because I am covered.
Submission, my lord, I will secure instruction, my lord. In this case, my lord, on the basis of Accountant General's observation, my lord, a demand notice has been issued straight away without even issuing a show cause notice. I am securing instructions, my lord, if you can withdraw this demand notice and start a fresh proceedings, I will secure that instructions.
Please. In an earlier ground, my lord, they had done that. my lord.
Start an adjudication process here. That instruction I will secure in a week's time.
So notice is based on the audit observation.
Audit observations, my lord, straight away a demand notice came to be issued to them without issuing any show cause notice and following an adjudication
There is
process.
some
basically.
judgment also that on the audit observation.
Yes, my lord. Yeah.
There.
Yes, my lord. In fact, in an earlier occasion,
Is of this court or?
this on the court only.
This one.
Yes.
Interim order was passed in this matter by the learned single judge, my lord, that came to be stated by your lordship. 25% deposit was there.
Yes, if you had contemplated to withdraw the notice, well and
I will take secure instructions and report. my lord.
learned.
A week's time.
Week's time, learned. There is.
My learned friend could do that before the learned single judge, then the writ petition will get disposed, my lord. Because what is challenged in the writ petition is the impugned order, which they want to withdraw.
Will dispose of appeal and writ petition both once he stays. 23rd?
Please.
23rd of February, to be listed at 2:30.
Great. Interim order may kindly be continued.
Interim order granted arrears will continue to operate till the next day.
Still number 25.
My lord, in 25, I appear for respondent number 1 and 2, my lord. Praise for a short accommodation, my lord. Today morning, papers were served on me. I need to file objection to the IAS, my lord.
It is only remanded.
Yes, my lord, but
Remanded, but I only agreed by one portion of the order. While remanding, my lord, the honorable learned single judge is also adjudicated on an issue at para 8. That's my, kindly see, my lord, page 37 is the impugned order. Page 42, kindly take page 41, my lord. Well, kindly see, my lord, the page 41 of the impugned order. Para 4, learned counsel for respondent on the other hand submits that order passed by respondent number 2 is based on factual aspects of the matter. Management had not authorized the person who signed the settlement. Same was not binding on respondent number 3, hence he seeks for dismissal petition. Sri Kumar Raman, learned counsel for the appearing for the respondent 1 and 2, submits that in facts and circumstances matter, respondent 2 may be directed to reconsider the case, keeping open all the contentions the parties in this to be urged. Further submits the order seems to have been passed based on contention urged by on behalf of respondent number 3. But if that is stopped, my lord, I have no grievance. Later on, my lord, heard later counsel petitioner of the learned counsel for respondents and peruse the matter on record. There is no dispute settlements dated 28/4/2017 as produced annexed H and J were entered into between the petitioner and respondent number 3 management. Though it is now contended that such settlement is not binding on the respondent management as the person who entered into the settlement on behalf of respondent 3 management had no authority, said condition give rise to 2 aspects of the matter. Firstly, admission of existence of settlement. Secondly, a purported dispute of the binding nature of settlement. Para 8 is important. If the first aspect is considered, management cannot contend it is not aware. Our whole contention is that we were not aware about the settlement. We have given a written representation at page 83, Lordship will get page 83. We have specifically said, my lord, it was neither brought to the notice of the competent authority director, nor any approval was given. And this conciliation was held on 27/4. Next day settlement was entered by a person who is not authorized to sign a settlement. main condition is taken. At page 83, we have specifically stated that fact. In spite of the manner, the learned single judge said cannot contend that it's not aware of settlement. Our main condition is that only.
So therefore, on their ground only it is remanded. Look at paragraph 9.
Yes.
Since the office is not adverted to side aspect of the matter and also the relief sought.
The management cannot contend that it's not aware of the period of settlement. That is very important. Man.
What do,
That's,
what's the stand? You are for
I appear for respondent number 3 and 4, my lord.
labor commissioner.
Yes.
My lord, I appear for respondent number 1 and 2, my lord. I
And
seek
I have
for
also taken a condition now.
Complaints.
The appellant is also does not accept the definition of industry on the industry dispute side. Also been taken. My humble submission, my lord, without reference to the para 8, all conditions are kept open. We'll take up the conditions before the authorities. Para 8 comes in the way, my lord. So must adjudication of the entire dispute. That is my main condition is that I was not aware of the settlement. At page 83, I specifically said so while giving my objections to the claim.
My lord, I pray for short accommodation. Matter may be taken up tomorrow or day after tomorrow, my lord. We'll place our statement of objection, my lord.
But my lord, my humble submission, they are now going before the commissioner and telling him there is no stay order is there, therefore you proceed.
My lord, have it tomorrow, my lord. Have it tomorrow, my lord. We will proceed with the matter. We will file the necessary objection and we will assist the court regarding, my lord.
That's it. They may I make one submission, my lords. Their grievance with regard to paragraph 7, observation that there is no dispute with regard to settlement. That's what the issue came up before the learned single judge, my lords.
Why do you want time, Mr.
My lord, I have not completed the pleading, my lord. I have not filed the objection. I received the copy today morning, my lord. Hence, my lord, kindly have it tomorrow or day after tomorrow, my lord. We will file the necessary objections.
What do you have to say about this contention?
My lord.
You also did not listen to what transpired in the court just now. Then it will go long. 13th March.
My lord, his commission is not waiting for, he says no stay order is there, therefore we will proceed with the
My lord,
cancelling.
tomorrow itself,
Only
I said.
pass an interim order.
We are passing better order of
Yes.
placing out in March, but rather than what we are going to pass just now. Next, 13th March. It is a better order for you.
My lord, please, my lord,
My lord, if he passes any other order, this becomes infectious for me. And he passes any order in between,
Pardon?
appeal, if he passes any order in between, it becomes infectious.
my lord, kindly have the matter tomorrow, my lord. I'll assist the court, my lord. Please, my lord.
All matters can be kept tomorrow.
My lord, difficulty is that, my lord, I received the papers today morning itself, my lord. Please, my lord.
All contents are kept open.
That is why.
Why?
Para 8, the learned single judge adjudicates a matter and then ultimately all contents kept open.
With the
My lord, if para 8 is diluted, I have no grievance. Para 8 is coming the way.
So, Mr. We will say all contents are open, including what is observed in paragraph 8.
Yes. Yes, it could be. Because very issue is the same, my lord. There is no other issue except this.
All is all. Observe. What matters is the operative cost.
Yes.
But as far as that issue is concerned, now my hands are closed because the Honorable Court says that cannot contend, you was not aware of that. My submission is I was not aware.
Third learned advocate, Mr. So-and-so for the appellant and learned
Respondent number 3 and 4.
3 and 4. And who are you are for?
My lord, respondent number 1 and 2, my lord.
1 and 2. On video, through video conference. Who made submissions through video conference? who appeared through video conference. The challenge in this appeal is directed against judgment in order dated 9th August, passed by learned single judge, whereby the writ appeal was allowed in part, issuing the following directions: B, C, D, E. As the operative direction suggests, as the above operative direction suggests, the learned single judge is only remitted back the matter for reconsideration by respondent to afresh. Full stop. It is also observed that all contentions are kept open. Full stop. Since the order is only of remand, the court is not inclined to interfere with the order. Learned advocate for the appellant, however, apprehended that observations in paragraph 8 of the order of learned single judge may. The case of the appellant, F8A complaint. In this regard, it is observed that since learned single judge has provided that all contentions are open, it is clarified that the contentions which be raised shall include in relation to what is observed in paragraph 8 also.
Right.
Also, this
Including, we have taken a contention. It's also not an industry, all contentions including industry.
this court has not gone into the merits of the matter. Since the case is remanded and the controversy shall be at large before the officer in its entirety.
Including industry.
Its entirety. Two times we have.
All contents are kept up.
This goes up in the aforesaid terms. Has not entertained. Appeal is not entertained, subject to limited of this.
Seven also, Lordship, it is 7 and 8, para 7 and 8.
All entirety. Yes.
December 26. Ganpati Bhatt.
In this case, I am appearing for petitioner.
26, yeah.
The petitioners, Lord, three petitioners have got query list granted by the Mines and Geology Department as per Lord Annexure ABC. That is query list deed has been submitted. That is dated 28/9/2017 for a period that is valid up to period of Lord 30 years. In this case, Lord, the subsequent to grant of query list, after taking fees, everything, that annexure F came to be passed, granting the same land, survey number 128 for burial ground. Now, my lord, these three queries which they are collected, they are demanding, my lord, the royalty, everything from me. And therefore, your lordship directed to take proper instruction from Deputy Commissioner and Tehsildar regarding the annexure F, which is passed in page number 177, my lord, which is, my lord, passed by the Deputy Commissioner. Translated copy 174. To be reserved the land, that is translated copy, my lord. Survey number 2 acres in survey number 128, situated Tavara Goppa village, Anvatti Hobli, Soraba Taluk, for the purpose of public burial ground. For that purpose, that the land should be reserved to the Panchayat Development Officer, so and so, so and so, so and so. This is dated 4/11/2020. After hearing this, my lord, this honorable court directed to take instruction from Deputy Commissioner whether this land will be changed or query list will be changed to the granted in.
Lord, lordship permit, my lord, a joint survey can be done, my lord. It is their case that there is overlapping, my lord. The land which was.
No,
granted
if
to
they
them
are
for quarry-
permitting us to carry out the query activities, no issue.
No, my
But
lord,
they have to take, because
Presence of the petitioners and the revenue authorities, my lord. If a joint survey is permitted by this court, my lord, the case is that there is a overlapping of the land, my lord. What has been granted by the deputy commissioner now, what is license has been granted for quarrying purpose to the petitioner, my lord.
photographs that I have produced, that in the ink page number 189. If they are conducting survey, let them conduct survey as to whether this falls within that. And if they are permitting, I have no issue. But the people, my lord, have put up a construction on the land, kindly see 189. That they have started, my lord, burning the bodies. Annexure G, ink page number 189. Photographs that I have produced. This has been constructed in the middle of the land. Therefore, if they are conducting survey and my lord clearing, I have no issue. Let them submit before this honorable court. Because from 2020, my lord, that we have given several representation and representations also has not been taken into consideration. Now they are demanding. Otherwise, they are threatening to cancel my query lease. Without, my lord, carry out the query activities, I have to pay royalty and dead rents.
They used for some burial purpose.
My lord, para 17 of the writ petition may kindly be seen, my lord. It is the case, my lord, the burial ground, what was granted to respondent number 8 is situated abetting the petitioner's query lease. Now they say that there is overlapping, my lord. Initially, para 17 may kindly be seen, my lord.
No, I can't.
They say is that it is abetting the petitioner's land, what was allotted to the burial ground. Now, my lord, on 13th August, my lord, an order came to be passed for the limited purpose notice was issued, my lord, saying to ascertain whether there is overlapping of the land. That is the question to be considered, my lord.
We issued notice.
Yes, notice has been issued. If they are conducting survey, let them conduct and submit before this court. And let them permit us, because Deputy Commissioner himself is the chairman of Task Force Committee for granting queries in favor of me. And advance royalty has been paid. I have paid all for required fees, everything that I have done. Therefore, if they are conducting survey along with Mines and Geology Department, 2 weeks time may be granted to them and conduct by issuing notice to us and submit it.
Very well, carry out.
Then, my lord.
That is to ascertain the
That will
identity of the
suffice.
land, my lord, basically, to identify the location of the land. Because the claim is made, they're saying that it is overlapping with
That is the order earlier.
13th of,
That is overlapping order.
13th
Yes.
of August, my lord. Please.
Area granted in converter which overlap the area.
Yes.
So only for limited purpose, my lord, a notice was issued.
You
We'll
take
conduct a
up-
spot survey, my lord, to rule out the,
Take out the measurement in his presence.
we'll do that in their presence, my lord. A
Do-
joint survey in the presence of revenue officers
For you.
as well as the
Do
petitioner.
it, comply with this,
Please.
learned additional government advocate. Sir, Harish submits with reference to order dated 13/8/24 that team of competent officers will undertake a survey to ascertain the aspect of alleged overlapping of the area of co-release granted in favor of 608 with the lease area of the petitioners. It was stated that by that the petition will be intimated.
Pardon me?
Petition will be intimated.
For conducting survey, you will intimate.
Then the survey will be undertaken.
Please,
Full stop.
With my lord, Mines and Geology Department.
And then responding to this, learned advocate for the petition, Mr. Ganpati Bhatt states that petition will remain present.
Yes.
The survey is conducted. After aforesaid exercise paragraph, necessary report may be placed on record of
Please.
present proceedings. Stand over to, we'll give 3 weeks time.
Please.
Please.
31st January.
Much.
Number 27.
Serial number 27, Your Lordship. I appear for the petitioner, Your Lordship. My apologies that I could not be there in person, Your Lordship, because of some personal inconvenience. Your Lordship, the issue at hand in this PIL is that the petitioner has challenged the amendment which is brought about by the state government on 17/3/2023.
Validity of 8A. Take long.
8A, yes, please, Your Lordship.
Come physically and argue. It will be better because of the subject matter.
A date may kindly be fixed in that case, Your
So
Lordship.
that is
My
better.
request, my humble request.
Even otherwise a long matter. So we'll,
My lord, my impleading application is pending, my lord, as a respondent. Come on record.
oh, who's the-
Representing the
on the
association.
same day we'll see. 25th of February.
Reading circle.
A shorter date may kindly be fixed. My humble request, Your Lordship. Today, because of some personal inconvenience, I could not
Maybe,
be there, Your Lordship.
14th February. 14th February. 14th.
Please, much of-
Please, Your Lordship.
December 28.
I appear for the petitioner, my lordship. I'm sorry, I'm appearing because of on video conferencing, my lordship, because of the personal inconvenience.
Yes.
The subject matter with respect of the encroachment of the lake, my lordship, water canal. And respondent level 11 and 12 and 13 is constructed the huge building on the lake, on the canal, my lordship. That was identified annexure C by the.
I appeal for respondent number 13, my lord. I am the owner. I have constructed as per sanction plan. I will file a detailed objection, my lord. And there is also another matter. Another person filed PIL saying that further construction shall not be done. Your lordship has passed an order. Except construction, we can proceed with that. That is regarding another writ petition. Now, regarding this, I will file a detailed objection. Your lordship kindly granted 2 weeks.
This is subject matter is others, my lordship. This is a lake, water canal. The construction is
lake,
water
flow.
Water canal, my lordship. That is
Canal. Not lake.
Was identified by the respondent number 8, and they conducted the survey on particular spot, and they identified that there is a water is flowing that was blocked by the number 12 and 13. And constructed the multi-storage building. That has to be removed.
Nothing of that sort, my lord. I'll find out, your lordship, what is the factual situation. I'll file within 2 weeks. I'll file detailed objections.
Who will file reply?
My lord, we all have to file a reply. It's one of the leading heart hospitals, my lord.
This one.
Respondent number 12.
Construction on the canal.
Yes, Rajakalu is in.
Two appears.
Yes. Construction is on.
Is on canal. From the photograph it appears.
Yes.
Yes, it is photographed.
You are for that hospital. Which is that hospital?
Narayana Health, my lord. Respondent number 12. My lords, I draw your attention to the prayers, my lords.
Narayana Health.
I'm disputing the documents, my lords. And if I draw your attention to prayer number D, it's actually, the petition is in the form of a application under RTI, my lords. They have no documents. Prayer number D, my lords.
D.
They are seeking a mandamus to produce all the relevant documents pertaining to the allotment of the plots and conduct survey.
Which prayer?
Prayer number D, my lords, to direct respondent number 5 to produce the DD, my lords, page number 29. It's E.
29.
D. D and E. They filed the petition based on an alleged annexure C, my lords.
Petitioner has produced something beyond photographs.
My lord.
We have not been producing any copies of that, my lord. I request my learned friend to give us the copies of those documents he is relying upon. We are not parties to those documents, nor it was done in our presence.
The council is appearing in your behalf.
No, he's for the petitioner, my lords.
Petition.
I am for the.
I already sent the entire document, my lordship, along with the notice.
No, it has
If he is
come.
not received, if he is
Yes.
not received, my learned friend, I'll hand over it.
Certainly, I have not received. Otherwise, why should I?
If it is not received, I'll
please
hand
send
over
a set of
personally.
copies you are relying upon.
Mr.
We are not
Petitioner.
parties to those proceedings.
Mr. Petitioner, you have produced anything beyond photograph that this is on the canal?
They rely on an annex.
There is a report, my lordship.
Have you
There is
produced?
a report filed, report submitted by the revenue authority.
We are asking the petitioner.
My lo-
Who appears?
Yes,
for
my
the-
lordship.
Who appears for the petitioner?
I'm
Have
appearing
you
petitioner.
produced any material to?
There is a report.
Where is that?
There is a report, annexure C, page number 88, my lordship. The report submitted by the revenue inspector, the translated copy, 88. Last bit from the bottom, fifth line onwards. After the and it is found that there has been an encroachment of the channel, and in order to mark the boundary edge of the channel surveyors, necessity is there and request to engage the surveyor measurement so and so. Then thereafter, my lordship, annexure E, my lordship. Annexure E prepared by the respond number 8.
This report at whose instance?
Petitioner's instance, my lords. Petitioner's instance.
I filed a representation annexure B, my lordship. As per my complaint, this is not my instruction, my lordship. I filed a complaint before the authority and alleging that there is a encroachment.
So there is a prima facie something against you.
My lords, this.
The nature of report of the revenue inspector.
Yes, yes. There's encroachment. my lord.
My lords, this report was taken without our presence.
Whatever it is, file your reply.
Please, my lords.
Reply shall be filed by all the respondents.
My lord,
My lord, I'll have to implement it, my lord, because my report says they have encroached. And it's a delicate issue considering that's the heart hospital.
Reply shall be filed including by respondent 5. KIDB.
KIDB.
respondent number 5 and 6, my lord. I'm
You are
appealing.
there.
for that.
File reply, you are also important.
My lord,
part.
Senior will, senior
Reply
was
is filed by junior. Matter is argued by senior. So often senior lose the matter.
my lord, a week's accommodation to price statement.
File.
Your Lordship, I take notice for respondent number 7, the Pollution Control Board in this matter. Copies may be served upon us to file the objections within the time, Lordship.
Pardon, you have not filed objection.
Copies have not been served upon the board to file objections, Your Lordship, in this matter.
Copies are served, my lord. As per 5 and 6 is served.
So heard learned counsel for the respective parties, it requires, it appears that all the respondents, including respondent number 5, Karnataka Industrial Area Development Board, shall have to file reply responding to the grievance and the controversy raised. Such reply shall be filed before the next date. The petition shall be listed on 28th, 3rd March. 3rd
Apply.
March. Full stop. In the meantime, learned record for the petitioners will ensure that copy of the petition along with the compilation, along with the annexes, is out to each of the respondents within 1 week from today.
Please, my lord.
Oh, Your Lordship.
Respondent number 13, I'll serve the copies to the 13, my lord.
Pollution Control Board is.
Everybody I served, my lord. They not get the document from their office.
Number 29.
Grateful, Your Lordship.
My lord,
Lord.
I apologize, my lord, in this matter, my lord, I pray for 2 weeks' time, my lord, this is with, sorry.
Lords, a matter of a grave importance, my lords. From 2023, the notice has been issued. Until date, the response has not been filed, my lords.
We'll see.
That's a short date, my lords.
So now 28.
Number 29.
29.
My lord, in this I pray for some time, my lord, though the matter is important because
So rule provides special provision for helmet for children.
no, for children
Yes, ma'am.
aged
Yes,
between
ma'am.
9 months and 7 years. My
There
lord,
is-
the problem is we have a difficulty with regard to non-availability of the harness belt that is to be used for these children, my lord. If my lord could grant me 3 weeks' time, my lord, I'll see that, my lord, again, the awareness is created, my lord, and some decision is arrived at so that I can place it before my lords. A meeting with the manufacturers.
We'll not grant 3 weeks, we'll grant 2 weeks.
Why am I blaming?
Report us what is going on. 29th of January,
Obligement.
as good as 3 weeks.
Great.
Yes, madam.
Mala?
See, this pertains to accidents.
Yes.
Now, because of highway safety, everyone knows most of the accidents are caused by overspeeding.
Yes.
When the law in the country stipulates that you cannot exceed more than 120 kilometers or something in the best possible highway in the country, why do you permit the manufacturers of cars and other vehicles to travel, to be so powerful that it travels beyond 120 kilometers? Probably your government can think of putting a curb on it. Central government is also over here.
Central government has to take that because we
Now, if
follow
that
the
happens, probably so many things will be taken care of. There won't be necessary for luxury cars also probably.
There are inherent problems within us. There are inherent problems within us.
See, these are artificial problems where innocent lives are put at risk. Huh? What we call in Hindi, "Bade baap ka bigda hua beta." They take their Audi cars, BMWs, and cause accidents.
One of the law commission's report on this issue was brought out, but not been settled on that point.
My lord, I'll make an attempt, my lord, with regard to that.
You should come out with some suggestion.
Yes, yes.
Still number 30. So Madhusudan Adiga.
Petitioner by me. On the last occasion, your lordship had directed the state to file its objections.
My lord, I'm filing my objections.
Copy is not served.
Give copy. Learned additional government advocate. For files.
This.
Objects, a copy of which is given today. To learned advocate. Petitioner full stop, therefore is place for time. Turned out to when?
Any date, ma'am.
17th February.
Much problem.
This is a madrasa.
Madrasa.
Yes, my lord.
Illegally
Residential
running in.
School in a centrally protected monument. That is all the prayer, ma'am.
We have filed our statement of objections with the photographs.
You're for
Yes,
archaeology.
yes.
Yeah, yeah.
So you do whatever you want to. Why we are dragging court into? We'll see.
70.
Still number 31. The Sohani, yeah.
I appear for the petitioner in this. I've filed this writ petition seeking direction from this honorable court.
This I'm filing a memo. My lord, the writ petition may be allowed.
I've sought for directions regarding implementation of Emblems and Names Act 1950 along with its rules.
New respondent.
Throwing burden on the court. We'll just look into it and then decide.
Yes, Your Lordship.
Let me.
There has been this.
I have not gone through in detail.
Yes.
22nd of this month.
Yes.
At 2:30.
Obliged.
That when the improper use of this emblem was the subject matter before the
Emblem for?
National and state emblems,
Okay.
names and emblems.
before
There's been
the
blatant misuse of,
misuse of
Fine, prayer of fine, increasing fine is concerned. Are there any rules?
please, my lord.
yes.
Which are these rules for imposing fine?
Lord, the rules are, my lord,
Now you tell us.
So
which-
the act and the rules are there, my lord.
the act is the state emblem of India.
Act is, yes. Where is the rules? Or keep this with keep rules and act with this, give me. So 22nd of January at 2:30.
The improper use of emblem, my lord, was the subject matter before the Madras High Court, not in a PIL, my lord, before the learned single judge. Lord, the learned single judge has passed some directions for the state therein. And he said how it has to be scrubbed for the usage of improper. I'm sorry, my lord, I have only one copy, my lord.
I'll give to court officer.
Please, my lord, I during the course of.
Tomorrow you give.
Please, great.
There are few directions which I've sought for in para 29D of para 29. That
Which-
also may kindly be considered.
Great.
Obliged.
Still number 32. To Suyo Gerale.
Lord, this is a mandamus to the central government, my lord.
I request, my lords.
week's accommodation, my lords. Senior, my lords, was
Prayer
supposed to
DC,
appear.
my lord.
My lords, there's a bereavement in his family, my lords, that is why. Lords, senior has been engaged in the
Settled.
matter. Lords, there's a bereavement in his family, that is why, my lords, I request for a week's accommodation.
What is this?
My lord, mandamus to consider the representation with regard to implementation of the 103rd Amendment to the Constitution, my lord, providing for reservations for economically weaker sections of society. It's just to consider the representation.
Oh, my lords, it's to implement, my lords, we have sought, not only to
They
consider.
are bound to implement, it is law. Will implement or not?
They have not implemented.
It's central government who has to implement.
Lord, I will, Lord, senior would address, my lords.
Very simple. Very simple answer is that they will implement. So why don't you complicate by bringing senior?
No positive direction can be given in a representation, my lord, to implement.
For deciding representative.
My lord may see to implement. A mandamus to implement. That is a positive direction. I can understand considering it and then the central government deciding to implement it.
It's for this. Actually, it's for the state.
Today is the right day for disposal of.
I request, my lords, at least, my lords, after 20th, my lords.
Very well.
After 20,
Please,
22nd at 2.
please,
All on 22nd disposal matter, yes.
much obliged.
No, it's for the state. Madam, it's for. Yes, next.
Number 33.
Let's appear for respondent 5
For
and
the
6.
petition on this matter. Case of encroachment again of stormwater drain and blatant constructions, buildings have been constructed. The government on the last date of hearing has submitted that action. Orders for demolition of these buildings have been passed, but I'm given to understand that no steps have been taken.
No, order has been passed, notice has been issued to him, my lord, to voluntarily.
The orders have been passed on June 2024, I understand.
Thereafter, this thing was, a notice was issued. My lord, I'll have to verify, my lord may have this on Monday.
Copy. Pass me the copy to me.
Eviction order is passed, my lord.
That's one more copy.
You are for whom?
5 and 6.
Take.
Possession is taken or not?
My lord, that I will verify. My lord may have this on Monday.
23 constructions are blatantly going on. There are people occupying, businesses running, but no action is being taken.
My lord,
These
I
orders
was
have been passed.
informed that a notice was issued, 15 days' time had been granted for them to, my lord, vacate. If that has not happened, my lord, I think the DC would have initiated action under section 39(3). My lord may have this, well, my lord may have this on Monday, my lord. I'll
Just make
inform my
one,
lord. as
may
to
just make one submission and clarify, my lords. Lords, I appear for respond number 5 and 6 in this matter. My lords, the order of the DC, my lords, passed pursuant to these proceedings, my lords, has been stayed, my lords, by the learned single judge. In the writ proceeding, my lords, may kindly permit me to pass on the order. I just have copies of the order, my lords, may I just pass on.
So please give me.
Lords, may just also place on record, my lords may kindly permit me. I just want to place on record, my lords, a very critical document. My lords may kindly permit.
Lord, orders passed by the Deputy Commissioner and pursuant to orders by this Honorable Court are challenged before the. Lord, I'm not made a party to these proceedings also.
So there is an order in respect of every building?
Same land, my lords, same order. DC passed an order, my lords, pursuant to their complaint. Lords, on a finding, my lords, on a finding, my lords, that the order of the DC is passed erroneously.
This petition is coming up when?
I'll take instructions on that regard. I don't know, my lords. My lord may kindly see, I've just produced, my lords, one aspect my lords may kindly consider. It's very important, my lords, simply because, my lords, I'm discharging my duties as an officer of the court. I filed an affidavit. My lords may kindly see just one aspect, my lords.
But in any case, this will not survive after Mr. Akbar's affidavit and you are producing this all.
My lords? No, this is not on the merit of the matter, my lords. My lords may just see for a moment. My lords may kindly.
Notice for removal of construction is given by them.
Yes.
You have obtained stay order against demolition.
Lords, simply because, my lords, I filed my statement of objections. I'm ready on the main merit.
Not survive. This petition will not survive for
The petition will survive because the reason is, my lord, it has not been given, it's not reached its logical conclusion as of now. Orders have been passed. And my lord, kindly see the actions.
Order
My
against
lord.
demolition. There is a stay order against demolition passed
But
by
may-
one single judge.
Kindly appreciate this fact, my lord. The orders were passed by the state in pursuance to orders by this honorable court in lieu of the petition. Now kindly see the petitioners of the respondent number 5-6 actions of moving the learned single judge in relation to orders passed by the deputy commissioner and furtherance to orders passed by this court. Those actions itself are impermissible, my lord.
Lords may just
Can you
make one
appreciate those?
submission if my lords.
They
may
don't
permit.
place statement of objections before this honorable court as well. Sorry.
Just one submission if my lords may permit. I filed an affidavit, my lords. The conduct of the petitioners, my lords, is shown in the affidavit. During the pendency of this petition, my lords, they go every day to the deputy commissioner and say that the matter is pending before the division bench of the High Court. They arm twist, my lords, the respond number 5 and 6 on that score. They have extorted 10 lakh rupees from me. The proof, my lords, is there along with that affidavit. From the respond number 5 and 6, the petitioner takes into his bank account a sum of rupees 10 lakhs during pendency of this writ appeal, PIL, my lords, in order to tell the petitioner that we will stop harassing you. On a finding, my lords, that it is not even a drain as determined by the DC.
Government, can you state under which provision of law this order has been passed? You have just now produced.
Can I make one submission? This order is passed by my lord.
No, not that.
On 27 November.
The DC has passed an order.
My lord has stayed that order on 27,
Correct.
11, 20.
I am asking you a question. Under what provision of law this order has been passed by the DC?
My lord, in the order, section 39(1).
Where does it so? Say so. Don't improvise. Read the Kannada version. Where does it say so? 39(1). Page number 6.
Page 7, my lord.
No, my lord's question is,
It doesn't mention the section. It doesn't mention the section. Maybe typographical mistake. It doesn't mention the section.
my lord, we do make some mistakes, human error, but I can prevail on the DC to see what can be done.
Yes.
Lords, may just submit, my lords, one aspect.
Even prior to this, orders have been passed by the DC. May I place those orders? This is what is supplied by the government to me. I'm sorry if I've placed these orders. 39 rule 1 and 3 orders have been passed by the Deputy Commissioner.
I'm not on the merit of the matter, but this needs warrants consideration at my lord's hands. Lords may kindly see, when this petition is filed, lords, during the pendency of the petition, they extort a sum of rupees 10 lakhs. I place the proof, my lords, on affidavit before my lords. It cannot be, my lords, that a PIL is filed and subsequently during the pendency of the PIL, my lords, they extort large sums of money from me.
When do you want?
My lord, I'm stuck because the order is stayed.
My lord,
17th March.
my lord, here is a case where directions of this honorable court during the matter being pending before this honorable court are being violated, my lord. And
Yeah.
behind
Then there is a stay operating.
Yes,
stay
I
of the deputy
noticed
commissioners, there is nothing stopping the
matter, but there's no further hearing.
my lord,
date
that's
given.
nothing stopping the deputy commissioner from taking action. If my lord will take up the matter at an earlier date, at least the state may consider taking fresh action, if that is the case. If the state has erred in passing an order, my lord, as the state may concede, if my lord may take it up on an earlier date and the state could take fresh action, if that is the case.
Sir, we'll work on the writ side, my lord, we'll file an IA for vacating, we'll see what can be done.
A date may kindly be fixed in February so that some action is taken, my lord, because admittedly there is an encroachment. All of these arguments aside, there is an encroachment admittedly.
February.
Grateful.
Lords, may I make a request, my lords? My affidavit may be taken on record, my lords, because I've produced the proof. They're all certified copies, bank records I've produced, my lords. During pendency of the petition, they take money from me.
A copy may be served on me because I don't know, allegations are being made against.
In open court, I'm producing it, my lords. I'll serve a copy to them right away.
Being taken on record and.
File in the registry. Yes, next.
Thirty-four is urgent, still number 35. Mr. E. Vinay Kumar, 35.
May be permitted to appear for the petition. This is a case wherein the application of the petitioner for mining lease has been considered, processed, and MDVPA has been executed, and mining lease has been executed, as per annexure L, page number 91. After completion of all the required formalities, mining lease has been executed. Annexure L, page number 105, please. 91. Now, my lord, after execution of this mining lease, the forest department has to execute an agreement. It is after forest clearance, mining lease has been granted. Now, only formality is to execute an agreement, that's all. They are delaying it, my lord, indefinitely. That is why we made a representation to execute the agreement at the earliest. Our prayer in this petition is to consider the representation in a time-bound manner to execute forest agreement. That's all the prayer in this petition, please.
My lord, we'll consider the representation in accordance with law.
Within a time-bound manner, a short time may be fixed.
8 weeks. 8 weeks.
2 weeks, blood, because everything is completed. Everything is completed.
6 years. 6. We passed here.
Yes.
You are also there.
Please, ma'am.
You the all appeal.
I appear for the
All
first
appeals.
response.
Today is 20. Today is 15.
Number 36.
I appear for the petitioner in this matter. In this matter, we have filed an application for my quarry lease, my lord. And a representation was filed to consider the same in accordance with the amended provisions of law.
Here you need to file reply probably, deemed action.
In the similar circumstances.
My
this
lord,
honorable
he
court,
was
my lord.
insisting for considering of his representation, my lord.
We have done the same.
Same. And the same day this was posted, but notice was issued.
All right. Madam, same way.
Here, the application is 8A.
That we'll see.
Yes. Okay. Public.
Number 37.
Lord, 37, Lord, happy for respond number 5. Bangalore Metro Rail Corporation, Lord. We have filed an application, Lord, seeking, Lord, to implement, Lord, the OM issued by the tree officer. Lord, as Lord's aware, Lord, that after issuance of Lord OM, we need to take, Lord, formal approval, Lord, permission of this court to, Lord, implement the OM. Lord, after, Lord, conducting spot inspection, Lord, the tree expert committee, Lord, has made recommendation. Based on that recommendation, Lord, tree officer has, Lord, issued OM. Lord, I have filed it on, Lord, 17th December 2024. IA, Lord, IA number 8.
17 December.
Please, Lord. IA for permission. Application for permission was filed on 17th December.
Who appears?
We appear for the petitioner, your lordship. We have filed our detailed objections in this regard. We only have a few objections to their application itself, your lordship. If I may take your lordship through these objections. Your lordship, firstly, if you may look at the OM that they have filed itself.
The Advocate General was appearing in this.
Lord, yes, appears, Lord. Mr. Dan Chinnappa, Lord, appears for Bangalore Metro Rail Corporation, Lord. Advocate General appears from, Lord, the rail infrastructure corridor.
Yeah.
There are two, Lord, organizations.
So there,
Yes, Lord, correct. Last occasion, Lord, Advocate General appeared.
railway part is over.
Yes, Lord. Lord, in this scheme, Lord, OM, Lord, only, Lord, 61 trees, Lord, have to 55 trees, Lord, have to be cut, Lord, 6, Lord, have to be translocated. Lord,
Yeah.
kindly come to page number 15 to my IAM, Lord, page number 15.
Page number
15, Lord, 15. To IA for permission. IA number 8.
page 18.
15, my lords.
15.
My lord, order, my lord. This is order issued under my lord 8.3 of my lord, the Preservation of Trees Act 1976.
So,
$15 sites, my lord, trees, my lord, are directed to be retained, my lord. 6 trees, my lord, translocation. And my lord, 55, my lord, needs to be removed, my lord, which are standing, my lord, in the project area of, my lord, the metro. Last, my lord, I've allowed, my lord, the similar IAS, my lord, and earlier. This
Your Lordship, if I may place my objections on this. While my learned friend submits that there are only 76 trees in this regard, what is to be noted, Your Lordship, is that this particular OM is not the first official memorandum for this particular project. From the official memorandum itself, it is forthcoming that this OM has been issued for the metro rail project from Kempapura to Bagalore Cross. Your Lordship, in 2022, another,
Clear. You know, to
we have filed our objections, Your Lordship.
remember similar matters. To argue.
Please, my lord. Kindly have the matter tomorrow or day after.
No, no.
There's an extreme urgency, my lord.
No, then,
Lord,
then
project.
argue the matter. Don't say
We'll argue,
similar-
we're not
Don't
not
know
saying
what
that.
similar matter.
Please, my lord, we'll argue.
Don't throw the burden on the court. You have to argue the matter, you have to point out what is the subject.
Please,
matter,
my lord,
what is
we'll argue.
prayer,
We'll
what is
argue the matter,
requirements.
my lord. I'm not saying that I'm
Argue
not.
then.
Lordship, kindly take my lord, I am lord.
You are just saying similar matter is disposed of. We don't know any similar matter. No counsel is similar, no matter is similar, and no judge is similar. Yes.
Lord. Lord, this, my lord, project, my lord, in respect of metro, my lord, for construction of, my lord, the elevated structures,
Cut trees.
please, my lord, cut trees.
Where is that order? Where is that order?
Lord, order, my lord, at annexure, my lord, A1, my lord, page number 10. Page number 10.
That order, the order which was passed in that railway IE. To bring that order. You seek order in the same lines.
Please, my lord. Four 2024, my lord.
List of
Lord.
trees we will be retaining. List of trees which are to be retained will not be cut.
Please, my lord. That, my lord, in respect of, my lord, the K ride, your lordship, my lord, allowed, my lord, that IA and 4/12/2024, order dated 4/12, your lordship, my lord, order 4/12/20.
Page 40 is what, your trees or railway trees? Akash Malige. This tree is healthy and standing within project.
That is in respect of BMR.
All trees are healthy. So dismissed. All trees are healthy.
Yes, my lord, there are reasons, my lord, I've been assured by my lord the tree.
This tree is mature, larger girth, limiting possibilities of excavation.
All
Limiting
process,
the-
all procedures have been followed by, my lord, the tree officer, my lord, the tree expert committee and, my lord, the tree officer. Thereafter, my lord, this OM has been issued, my lord, imposing, my lord, certain conditions on, my lord, the metro. My lord,
Where is your IE? Where is it?
IAM, sir. It was filed on 17 December.
Same. You are Bangalore Metro.
Yes, my lord. Respond number 5.
Who appears for the tree officer?
Lord, BBM,
Lord.
government.
Shall they be permitted to cut the trees?
Page 10, my lord, is the order. Page 10, my lord, is the order.
So you want Bangalore without trees?
Lord,
Ever heard?
My lord, could I seek for some time in this matter, my lord?
You will look into it.
Lord, next week, any day at 2:30, my lord. Every day, my lord, the metro is losing, my lord.
19th February.
Lord, there's an extreme urgent. Next week, my lord. Next week, any date.
No, next.
20th. Pradeep.
38.
Petition. In 38, you have filed reply.
My lord, in 38, Lord, it's a simple issue. Yes, some affidavits have been filed reporting compliance.
Some liquor stops are.
Yes, my lord,
Cancel.
according to them, liquor, CL2 and CL9 licenses have been shifted from other places to this 100-feet road. My lord, my submission to my lord is from the year 1982, no fresh CL2, CL9 licenses have been granted.
From 92.
82.
82.
Yes. My lord, there are as many as 80 licenses here. Any violations, my lord, by these CL2 and CL9 licenses are dealt with, my lord, by the deputy commissioner. My lord, and accordingly orders are passed.
That is one of the contentions. The petitioners here represent around 2,000 residents of Indiranagar. Within a span of 2 kilometers, there are over 100 establishments which serve liquor. When the petition was filed, that might have varied today. So aggrieved by the nuisance being caused, today the petition was filed seeking implementation of various laws, including excise laws, BBMP municipal laws, and certain other directions issued by the police commissioner itself, which the Honorable Supreme Court had upheld and issued further directions. Today, IA number 1, which I have filed, pertains to certain directions issued by the Honorable Supreme Court. My request to the Honorable Court to kindly look at one order passed by this Honorable Court itself of 2nd February 2021, para 7. This Honorable Court had recorded this pertains to the licensing and controlling of places of public entertainment order issued by the police commissioner, which required places which either have live music or recorded music being played to obtain a license from the police commissioner. Now, this went up all the way up to the Honorable Supreme Court, which upheld the constitutionality of this order. The Honorable Supreme Court also passed certain further directions to the police commissioner. In this context, this Honorable Court on 2nd February, may I request the Honorable Court to kindly look at that order of 2nd February 2021 at para 7, Your Lordships.
February.
2nd February, Your Lordship. 2nd February 2021, para 7. This Honorable Court's order sheet. May I start with para 2, Your Lordship? Essentially, this public interest litigation concerns two aspects. First is with regard to the grievance sought to be made out by the petitioners vis-a-vis noise pollution caused by those establishments who may be license holders in Indiranagar area of Bengaluru city, who are also having the facility of live band as defined in clause 2J of the licensing and controlling of places of public entertainment, Bangalore City Order 2005. In that regard, the question is whether the government order dated so-and-so has been complied with by the establishments in Indiranagar or not. Second aspect of the matter is with regard to there being alleged violation of the Karnataka excise sale of Indian and foreign liquor rules 1968, and in particular Rule 39 of the said rules, particularly proviso thereto, which has been inserted with effect from so-and-so. On the first aspect, the Honorable Court goes on. I'll just take the Honorable Court to para 7, which is the second aspect, which pertains to IA number 1, which is before this Honorable Court today. I request the Honorable Court to kindly look at para 7, Your Lordships. No. The Honorable Court also extracts the Supreme Court judgment, and then at para 7, therefore, learned counsel for the petitioners contended that it is high time that the dictum of the Honorable Supreme Court in light of the government order dated 9/12/2005 is implemented in letter and spirit, as it is his contention that there may be several such establishments which may not have obtained any license under the government order dated 9/12/2005 in Indiranagar, which is essentially a residential area. Since it is the duty of the Commissioner of Police, Bengaluru, to implement the aforesaid directions of the Honorable Supreme Court issued in light of the said government order, we direct the Commissioner of Police to file a status report in that regard, insofar as Indiranagar area is concerned, as the writ petition pertains to Indiranagar only. Said report shall be filed within a period of 2 weeks. Thereafter, the Honorable DCP has filed a report on 8th of November 2021, in which he confirms that there's only one license issued in the entire city of Bangalore. This was subsequently, there was another status report of 16th March 2022, where the DCP Bangalore East records that there have been multiple violations of this order and steps are being taken to prosecute those who are violating this order. Thereafter, no action has been taken, and we have filed this IA today, requesting the Honorable Court to direct them to conduct surprise inspections and file a report with this court pertaining to the implementation of this order. May I request the Honorable Court to kindly look at just one paragraph of the judgment of the Honorable Supreme Court, which is produced along with my writ petition itself, Your Lordships. Page 213, Annexure T is the Supreme Court judgment in this regard. Lordship.
Affidavit is filed.
Your Lordship.
Affidavit is filed.
Affidavits were filed. The DCP recorded that there's only one license given for the entire city of Bangalore. Thereafter, another affidavit was filed in 2022 clarifying that multiple violations have been noticed and action is being taken. However, thereafter, no report has been forthcoming from the state, which is why we have filed this IA requesting the Honorable Court to direct them to conduct a surprise inspection and file an updated report with this Honorable Court. Because today, this continues to be violated. There are specific directions by the Honorable Supreme Court, which also judgment I have placed before this Honorable Court. That starts at page 213 of the petition itself.
If a copy of that IA is given, I'll see to it. My lord may grant me some time and I'll file the report, my lord.
I will serve another.
Please serve it.
It was already given. I'll serve another.
This is of 2019. For 27th February.
Obliged. ma'am.
Yes. So may I request the government file an updated status report by that date? I will immediately serve an IA. Save the IA. Another copy.
February, learned 2025, learned additional advocate shall file affidavit pointing out the latest developments.
Obliged.
Obliged. ma'am.
Is there any prayer for removal of the shop?
My lord, the prayer is,
Your Lordship, the prayers are only
Not
regarding implementation of the existing laws. We have not asked for any other directions because the existing laws itself are sufficient to safeguard the interest, but they're not being implemented.
It's a residential area.
Residential area,
now it's
purely. I have
converted
produced,
into a non-residential area. They're seeking
is.
for not to grant. My lord,
not to grant is not a relief. We have-
licenses have already been granted. They say that if there are any violations, then to cancel the license.
That's all we are asking for.
From 1982, we haven't been granting.
Your Lordship, may kindly see, I've produced data from the revised master plan of the Bangalore city itself to show that this is a purely residential area. Maybe a couple of main roads are permitting mutation corridors where commercial activities may be permitted, but predominantly it's a residential area itself.
The license is granted for 3 years or 5 years.
My lord, every year it is renewed. Once it is granted, every year from the 1st of July, it is renewed. No fresh licenses are granted. They are only seeking for shifting and they have come over to Indira Nagar. my lord.
Obliged.
39 urgent, seal number 40. Mr. Rajesh Gowda.
In this matter, my lords, the land in question has been given by the state government to the slum clearance board, my lords.
File 3 IAs. Need to file an objections with respect to 3 IAs.
I will not argue on those IAs, my lords. Here, my lord, concealing the fact, my lords, he had filed an application for the land in question. His application is rejected. Subsequently, he files a public interest petition, my lords, saying that the land should not be given to the slum clearance, and nearly all the 45 houses have been constructed. In view of the status quo, my lords, we are not able to complete the houses and give it to the slum dwellers, my lords. In fact, he is an applicant for this land. His application has been rejected. And nearly the.
No, that's not a correct statement.
Yes, page 39 and 42, kindly see of the statement of objections. The 48 and 53 of the statement of objections.
48?
And 53.
State government.
Filed by respondent number 4, slum clearance board.
No.
48, my lords.
No, 48.
Some representations.
Correct, for representation to allot this land to the petitioner, second petitioner.
No, this is not by one Srimati Radha has filed it.
Yes, that's the second petitioner. And the second petition endorsement, page 53, the first petition application has been rejected. Well, nothing but abuse of process of law, my lords.
This, I'll just run this across, let it be taken up next week, Lords. Lords, I just wanted to bring to your Lordships notice on the basis of instructions because those documents are not yet before your Lordships. Lords, this was an erstwhile quarry. There was a pit. Lords, the villagers filled this up
and thereafterwards made representations right from 98, 99 that it should be reserved as a ground. Then when the representations were pending consideration, Lords, the land was sought to be reserved under Section 71 of the Karnataka Land Revenue Act for various purposes. Lords, those orders were recalled by the government itself on the basis of the objections filed by the villagers, by taking into account that this lung space is required to be reserved for the village because there is no further lung space available in the entire locality. Those records are available with me. We wanted to file it, Lords, if.
No,
Your Lordships, those-
preliminary
I will-
objection,
I
preliminary
will-
objection
I'll
is,
file all those documents and then convince your Lordships that the government was conscious of the fact that earlier occasions, they have de-reserved this because under Section 71 for other public purposes, they said they are reserving this. After considering the representation that this is required to be left as a number one, a lung space and a playground for all the persons, they have taken a conscious decision. Now they cannot say that, no, we do not want to again, de-reserve this from a lung space into a constructed activity. Slum, my lords, these are all small because whether it will certainly accommodate or not is one of the questions. I have got those documents, my lords, where they had taken two decisions earlier, they have recalled it. Lords may accommodate by Monday or Tuesday, my lords, I'll place it before the court.
Lord, humble submission, my lord. And for the impleading applicant, my lord, my application is pending. I'm the allotee.
my lord, my only humble request is, my lord, let him place whatever he wants. The question is, my lord, whether he has filed application for
We have not
allotment of this land to
They have
them.
not filed, my lords, that's, I mean,
My lord, there's an affidavit,
as-
there's an application which we have filed, which has been.
we'll
rejected.
respond to that. We'll respond to that by objections. We are yet to file our objections. We'll respond to that.
And one more thing, there's a police complaint against the very same petitioner. And anyway, matters being adjourned, I don't want to argue,
I'll-
my lord.
I'll-
Can I have it on?
Please, answer.
Irli.
Please, my lord.
It's slum development, right?
It's a slum development board, my lord. Under Section 71 of the Land Revenue Act, my lord, the state government has given the land to the slum clearance board. And pursuant to which the slum clearance board has constructed houses on this
No,
property. Houses, my lord. Photographs are there, my lord. And concealing all these facts, my lords,
First, ಅದನ್ನ ನೋಡಿ ನೀವೇ ಅರ್ಜಿ ಹಾಕಿದಿರಲ್ಲ petitioner. Deny ಮಾಡಿ.
So she is running a college, is that?
absolutely, my lords.
And she is asking for allotment of that land to the college.
And in the name of villages, 1,500 villages, well, nothing but abuse of process of law.
Lords, if this was a conscious decision taken by the government saying that it requires to be reserved as a lung space and a playground in an earlier occasion, then they cannot go back and say that, no, we don't want to reserve it as a lung space and a playground. Let them indicate where is any civic community available in the entire village.
Yes, we will show that.
Yes, that is not something which is forthcoming. They always, I'll file my detailed objections, my lords. Your lordships may accommodate by 3 to 4 days. By Tuesday or Wednesday, I'll be before your lordships.
On compelled submission, my lord, an impleading application is
29.
pending consideration.
29.
I'm the allotee, my lord.
Lords,
That application may be considered, my lord. My
Let it
impleading
come out to
application, yes, my lord.
25.
Didn't file any objection to my application.
65.
Please, my lords.
In one matter, your presence is badly needed.
In all the matters where he,
65. 65.
Lords, I'm sorry, my lords. Is there any matter which I missed out? my lords?
67, sorry, 67.
67.
wherever there's a trouble, my lord, my friend is there.
Oh, he is a troubleshooter. Whenever you are here, we take.
Yeah, the 67 years.
Okay.
What was it mentioned? 67 is a matter wherein we are in, there is a contempt petition filed along with the appeal of writ petition. So that appeal, Ozone.
Sarvan is appearing. My colleague, it appears, my lords, my office colleague is appearing in that matter. I'll take instructions and be before your lords. I'm lacking instructions as of now, immediately, my lords, to make any submissions. I'll take instructions.
Counsel is coming from.
Lords, I had the informed, my lords, probably my colleague, he left early for the day because it was his birthday, probably he wanted to celebrate it with his family. So he left a little early. I cannot complain it against him.
Everybody celebrates the family.
And so It's a great difficulty to come from all the way from Delhi, Lordships, and not. get
Had
an-
they just kept us informed, my lords, we would not have inconvenienced a lawyer. That much I can assure, that if they had just kept us informed, we would not have inconvenienced them.
Lordship may fix a short date on,
Any
fix
date,
it
my lords.
for
If your lordship
2:30.
fixes, I'll be before your lordships, my lords.
It can be 4th February,
Lordships,
4th February, 3rd February,
Any day, my
3rd
lords.
or 4th February.
Please.
third is fine, Lordships.
3rd is,
Yes.
4th, keep it 4th.
Fourth is also fine, Lordships.
could it be in the top 10 matter?
At 2:30, Lordship may fix it at 2:30.
And make a mention, my lords. I'll be before your lords. Just
Your
let them
lordships
keep me informed when they are making a mention, my lords. I'll share my number so that I'll not inconvenience the lawyers. That much they can be certain. Great to know.
Grateful.
When did it go? So when did it go? AG doesn't have file. Oh, I can find
The complaints in contempt matter.
This matter, we have filed our compliance affidavit.
To Prakash image.
For the complainant, your lordship, we have not received any affidavit, not the instruction.
Why you are not serving us?
So all services are done through email, my lords. Our office follows that procedure. Because otherwise we can't even file before the bench.
We have
They
checked,
wouldn't
but we have
checked
not
the-
received the compliance of affidavit, your lordship.
Unless we show that we have sent it, they will not
Not
take it in the,
accept,
accept
not
the.
Your lordship, it's my genuine submission, we have not received it.
Doesn't matter now.
That's- So
What is it? about?
Your lordship, the matter may be taken on Monday, your lordship.
Right.
Representations for Durast work in respect of land, survey number 363, within a period of 4 months. Done?
Lots, it's been done. We have filed also. It was placed before the missing committee, my lords, because the records were not available. The missing committee has given a report that it cannot be done. Therefore, it's been rejected.
Lordship, a short accommodation because I have not got any instruction regarding this.
22nd at 2:30.
Oblige, your lordship.
If I may mention serial number 72, my lords. The date may be fixed. This is a match for the order of the learned single judge, where we represent the order, where the learned single judge felt that lands falling within the BBMP limits do not come under the Karnataka Land Revenue Act. There's some urgency, my lord.
It is under office objection.
So office objection, my lord, we were not parties in the original writ petition.
So
The
serial
office
number
objection
4.
will be overruled.
Office objection shall be removed within 4 weeks.
Look, office objection.
Same 71 also same order. Then 72, what is 72?
72, my lord, annexure was not produced in the original writ petition itself. So what happened was, my lords, earlier there was a writ petition filed where, though I was made a party, notice was not served upon me, and without notice being served upon me, it was disposed. I filed another writ petition seeking review of the said order. Now the office objection is that annexure L in the original writ petition is not introduced. As it stands, the original writ petition also annexure L was not there.
You satisfy the office that compare both and remove.
Maybe overruled, my lord, maybe.
Learned advocate states that the annexure in respect of which the objection is raised was not produced in the previous petition as well. Also, this aspect may be demonstrated before the registry. If the registry is satisfied, the appeal shall be listed within 10 days.
Date may be, my lord.
Once you satisfy, registry.
13th of February.
Once you satisfy the registry that there is no office objection, yes, next.
Because
My lord, item 63-4, my lord. My lord, item 64.
Item number 47, my lords. They had filed a review petition, my lords, which has now come to be dismissed, my lords. So this contempt.
Request a week's time, my lord. I file an affidavit in that, my lord, because review petition
Was filed and it was also dismissed, my lords.
So then you have to comply with it. So to be listed on Monday
Please,
at
my lords.
2:30.
Yes, for 2 weeks.
My lords, on Monday, maybe.
No, we'll grant you the time, but let us
Yes, yes.
Please, my lords.
Yes.
Please, my lords.
on 20th at 2:30.
Oblige me.
My lord, item
Case
64.
number 52, my lords. It's a contempt case wherein the BBMP council had already undertaken to comply with it, my lords. 4 weeks' time was previously granted to comply with the order.
Now all contempts which are today could not be reached, may be distributed.
Please, my lord.
Within 2 weeks will be distributed.
Please.
My lord, item
My lord,
64,
Sarah-
my lord, they mention item 64. My lord, the writ was dismissed because there was an arbitration and disputed questions of fact. The vacation bench is granted a stay and the project is not going on. Can I request to borrow next week, my lord? My lord, any shortest date, my lord, because this has some national importance. The chemical being produced is unable to be because of the interim order.
Benches granted stay.
Yes, the vacation bench is granted a
There
stay.
is no ground to keep it early. It is a good ground to take the matter belated.
No, my lord, the difficulty is I am the respondent. And I'm suffering
Maybe.
the interim order because the writ was dismissed saying go for arbitration.
Which is that number?
64, my lord.
54.
60.
64.
Yes. My lord, India is already behind in production. We have now the central government has started this production, but because of this, the project is stuck.
18th February.
Lord, kindly consider next week, my lord.
Not possible.
My lord,
Number 50.
15.
50.
5 years, yes. Pardon?
Before
This was the. 51.
50?
51.
What do you?
Number 51.
What do you? Let him say what he wants to say. Why you are hesitating? Nothing is secret here. What is it? Mention whatever you want to.
This was disposed by the part of the bench.
Disposed by me, by my brother. All right. Not to be placed before the bench where one of us can do it.
my lord, serial number 77, my lords.
My Arun Bracketor is a member.
My lord, serial number 77, my lords. It is writ appeal for not granting the
Not granting
the benefits under resettlement and rehabilitation screen project, my lords. The appellant is 92 old, the project displaced person, my lord. Kindly have a date.
24th January.
My lord,
24th January.
24, my job list.
My lord, serial number 80, I'm a proxy counsel appearing in the matter. The office of victims have been complied with, my lords. It's right for notice. The matter may be had anytime next week, my lords.
80.
80.
80. Appeal may be listed on 28th January.
Much of that.
Serial number 48.
40?
48.
48.
Hard date making, they have to give a reply. Hard date making. They have to file a reply mail. 48.
So time you want time?
Yeah.
March, 10th March.
Hard date making give.
So wherever office objections are for 4th time, 5th time, 6th time, 7th time. So office objections will be removed within 2 weeks, failing which the appeal oblique petition oblique contempt petition shall stand dismissed automatically without reference to or order of the court.
Serial number 64. They wanted to be extended more.
All interim orders will be extended.
Serial number 42, my lords, contempt matter against the order dated 18/7/23. Till now, I have not received any benefits, my lords. An earlier date, my lords, if.
Date now will be
In